Morning, please be seated. Thank you. All right, we have all of our jurors and alternates. Anything from the state?
Yes, Your Honor. So I brought this up to Mr. Willis over the weekend. This is in regard to one of their witnesses that I believe they intend to call Dr. Andrea Elcon. She is the psychologist who did the psychological evaluation on the defendant. And one of the things that she reviewed in her, to base her opinion off of, was jail medical records. They had jail medical records obtained, and she reviewed those medical records and used them as a basis to part of her opinion. I asked for those medical records to be turned over by defense, and defense will not provide the medical records to me on the basis of basically them being privileged and confidential. I explained to Mr. Willis, he knows that we are going to bring this up this morning, that the state's understanding is that that privilege has been waived by the defendant. That, of course, medical records, she's the only one who can waive that privilege. Those medical records are confidential unless she waives that privilege. And the reason why I believe that that privilege has been waived, Judge, is part of what Dr. Elcon did in her evaluation of the defendant was she informed Ms. Mericle of her rights, and she explained that their interaction did not constitute a typical psychologist-patient relationship, and that says...
Well, if the expert, I mean, it's for expert testimony, correct?
Correct.
And it's the expert relied upon said medical records.
Correct. And she also informed the defendant that the assessment would not be confidential, and that basically everything that they discuss and talk about is non-confidential. It's a non-confidential assessment, and that her participation is voluntary, and that anything that they use can be used in court.
Defense, where are we on this?
Judge, to be clear, we're talking about two different types of records. So there's medical records. These are jail medical records. from her incarceration. Then there is counseling records, which are also contained within said document. So we've got medical, right? And we also have counseling, okay? So it's important to know we got two different kinds, all right? With respect to the medical records, there's a HIPAA protection that applies. The court can pierce that. You may make that finding. If you do, very well. With respect to the counseling records, 1716-4B2, which is the criminal discovery statute, says expressly in B2 that nothing in this code section requires the disclosure of any mental note or memorandum relating to psychiatric or psychological treatment or therapy of any defendant. So we've got some statutory protection here that's express. We also have the federal HIPAA protection. So I want the court to be aware of that. My position is that as the defendant, we don't have to provide that to the state. If the court...
So I would tend to agree with that general concept. You don't have to provide it, but I think we're getting into a different area if your expert's going to testify having relied upon that.
What I did, Judge, after receiving the message from Ms. Bennett, was I contacted Dr. Elkon and said, what did you rely on? I know what's referenced in the report, and I created a redacted copy that just contains everything she actually relied on. But again, and I have it here, I will produce it, but I will only do so if the court is directing me to do that.
All right. Appreciate the heads up. I'm not going to make a ruling right now. What else do we have?
Judge, the state is going to object at this point to Mr. Willis displaying his notes on an easel to the jury. He's basically publishing, and cherry picking his notes from the witness's testimony and then publishing it to the jury. That's improper, and so we object to that. It's also obstructing our view of the witness. We can't see what he's writing, and it would be simply like me putting my notes up on the Elmo as the witness is testifying. It's just not an appropriate thing to be doing. We object.
So I'll overrule that except for the part that defense needs to be better about displaying and not obstructing.
I agree.
Anything else from the state?
No, Your Honor.
Anything else from the defense?
Judge, with respect to a witness issue, there is a deputy, I think he's a deputy, maybe a lieutenant. His name is Christian Ingalls. He was served by the state. We've been trying to get a subpoena to him, another subpoena, even though he was already served by them. And we've gone to court services to do that. He's on duty, I think, today. I just want to be able to represent to Officer or Deputy Ingalls or Lieutenant, I'm not sure what his rank is. I want to be able to represent to him that that he should come when we ask him to come to the police court.
What efforts did you make to subpoena the witness other than relying upon the state?
We have contacted him this weekend. He said he would accept a subpoena by email, and then we've taken it to court services for service. And of course, it is the court subpoena. I know when parties serve, but it is the court subpoena.
No, I understand that, but, if you served him 2 weeks ago and that person's not here, that's a much different kettle of fish than emailing someone this weekend, so. I mean, have you legally subpoenaed the person?
Well, he's been served through court services and previously by the state.
I'm not concerned about the state, I'm concerned about y'all. When did you legally serve him?
I think we have carried it down there this morning.
Okay, well.
Is that correct, Karen?
You gotta serve within 24 hours. So,
Yep, it's 24 hours. Yes, sir.
If it becomes an issue, let me know, but
Okay.
Certainly the court would be very displeased if this had occurred 2 weeks ago and you were getting the runaround, but
I'm not suggesting that that's what he's doing. I don't want to tell him you need to be here unless I have authority to do that. That's why I'm asking the court for that. But I understand what
Well, I mean,
the court
if
is.
you legally subpoenaed someone, I mean, there's a 24-hour window, so if he's legally subpoenaed, let's say right now, and you want him to show up tomorrow at 9:30, then we're gonna have a problem if he's not here at 9:30, hypothetically. All right, what else?
Nothing from the state, Judge.
Nothing further from us.
Let's bring him back. Thank you.
I'm sorry. Yeah, not a lot. Yeah, yeah. Oh, sorry, yeah.
Good morning, welcome back. Thank you. All right, welcome back. Thank you so much. Good to see everyone back. All right, please be seated. Thank you so much. All right, we're continuing testimony. Thank you so much. Still under oath, still with the state.
Investigator Mefford. Okay. I want to ask you a couple brief questions about the interview that you had with the defendant. We see at one point in the end of the towards the end of the interview, you exit the room, but Investigator Cuneo stays in the room. Was there a particular reason for that, or did you just leave and she decided to stay?
No, so we always do interviews with two people. We're interviewing females. I like to do an interview with a male and a female because I have to do the interview. Now Sergeant Cuneo was my pick for this interview. When we do interviews, we try to establish what's called rapport. It's more of a connection with people, and sometimes there can be issues, whether male, female, stuff like that. And during this portion, I did exit and to see if there was any more story, confidence, or anything within to leave that there. So there is strategy to that.
And when you exited and Sergeant Cuneo stayed in the room with the defendant, did you note any, I guess, topics where the defendant did appear to open up a little bit more with Sergeant Cuneo?
Yes.
Could you give an example of that?
She was telling me there was nothing on her phone, nothing to worry about, but she did tell Sergeant Cuneo about the text message with Mr. English.
And is that something, the text messages with Mr. English, was that something that she had ever talked to you about, she being the defendant?
No, she told me there was nothing on her phone.
Besides the Mr. English text messages, did the defendant open up to Sergeant Cuneo about anything else while you were out of the room?
No, I do not believe so.
We saw in there that you were taking photographs of her injuries, the defendant's injury, or like the bruising that you saw that you personally witnessed on her arm. Do you know the time that those photographs were taken?
If you're referring to states 221 through 226, it was 6:30 a.m.
And 6:30 a.m. on March 8th?
That is correct.
Okay. You talked about last week your experience in law enforcement, that you worked in Forsyth County, you worked in Jackson County, and then Hall County. Throughout your experience in law enforcement, has there ever been an occasion where you've had to go up and knock on someone's front door to try and speak with them?
Yes.
Have you ever experienced a situation where that individual did not want to come out of the house?
Yes.
Have you ever experienced a situation where you had to end up kind of interacting or speaking with someone that was on the other side of a door?
Yes.
Did you have any trouble, or were you able to kind of determine where that individual was standing based off of being able to hear them speak to you through the door?
Yes.
You did have trouble?
No, I apologize. No, I could understand and figure out. I was able to get a feel for where they were to position myself better.
And if you had suspicion to believe that some individual on the other side of a door was holding a firearm, is there a particular way that you would position yourself at the door to protect yourself?
Yes, so along with being a firearm instructor, while I was on patrol, I was also, still and currently a certified field training officer. And we do train new recruits to always take more of a defensive position. It's all about protection. You want everybody to go home at the end of the day. So you never want to stand solely in front of the door. You want to try to find some cover, what we saw, something would stop bullets if they were flying. So you want to stand adjacent to the door off to the side, preferably on the opposite side that the door opens. So when it opens, you can get a better visual into the room.
And so when you say, like, standing off to the side, could you maybe just stand up and pretend like the entranceway to the witness box is a door? Like, how would you be standing if that were a door?
So just like, if this was the door, we're going to pretend that the door opens this way, either way, just this way. I wouldn't want to be on this side. Let's say this wall's not here, and you can kind of get further. I wouldn't want to be on here because when the door opens, I'm only looking at solid door. So the way we teach the new recruits is stand on the opposite side. Hopefully there's bricks, there's wood, and there's studs. There's something that could slow down a bullet, stop a bullet if it were to come through. So you give yourself that much protection. If there's a window there, like a lot of your modern constructions have, you'll stand further off than that window and still be able to use that window. But that way, when the door opens, as it opens, you have visual into the room.
Have there been circumstances where you, in order to protect yourself from a potential firearm on the other side of the door, would you stand like with your body turned to the side, or would you stand with your body facing forward, or something different?
Well, you would blade your body, yes.
What does that mean, to blade your body?
I apologize. Yes, you would kind of cant your body to the side. The idea is to make the target small as possible.
And you also mentioned that you were a firearms instructor last week.
Yes.
Certified firearms instructor.
Yes.
So could you just explain, if someone is like not super experienced with firearms, they're just learning the fundamentals of handling a firearm, what's involved with that? What's involved with someone who's just learning the fundamentals of controlling and handling a firearm?
So, and here at the county, what we do a Glock orientation program for jailers that want to go to the academy, and they are taught to shoot at that time. And during that time, it's fundamentals. You're taught sight alignment, sight picture, breath control, trigger control, stance, grip, those things. And while you're honing in on these skills, you usually only fire one shot at a time. We wait till you get a little more advanced and a little more comfortable with the basic skills before you start adding follow-up shots. So yes, it's usually one shot, and then focus on the fundamental, focus on the follow-through, release the trigger, you can feel the reset, stuff like that.
So, for example, someone who is basically at the fundamentals level of shooting a firearm, and they go to a gun range, would they be trained to shoot one at a time at the target that they're shooting, or would they at some point be shooting multiple quick fires in succession?
So typically at gun ranges, you can't shoot rapid fire anyway at your public gun range. But usually when it comes to, or typically when it comes to the new shooter, the novice shooter, you still focus on fundamentals. It's one shot at a time.
I want to bring your attention back to the search warrant you did of the defendant's phone. Last week, we talked about some text messages that you'd had a chance to review between the defendant and the victim. And I think I had asked you, this might have been where we ended, if you'd also had the chance to review some Cellbrite reports that were from the defendant's phone number. Were you able to do that?
Yes.
So then, again, I'm going to show you, just for the record, this is 199 DORNH.
Which of these have been admitted already?
None of them.
None of them?
Mhm.
Okay, there's your notes. 199 of those notes. Gotcha. This is this. Is that an O or a D?
That's a D.
Okay,
That's the O.
this is the calls. Okay,
Get the D a little bit more D-like. If you could just take a look at, I know the letters are all out of order, I'll try again. We got D, 199D, 199H, 199O, 199R, and 199N.
And while the witness is doing that, may we approach?
Have you had a chance to review all of those reports from the defendant's phone?
Yes.
Judge, at this time I move to tender states 199D, 199H, 199N, 199O, and 199R into evidence.
Admitted pursuant to prior objection as noted. Thank you.
Thank you, Your Honor. Permission to publish, Your Honor?
Yes.
I want to start with 199D. So 199D is one page. I'm going to try and zoom out just a little bit. What are we looking at in 199D?
This is going to be the call history, I believe, of March 8th. The morning, yes.
And is this call history from the defendant's cell phone?
That is correct.
So we see at 1:10, this is March 8th at 1:10 a.m., there's an outgoing 911 call. That's 45 seconds. Is that correct?
That is correct.
And then below that, what's below that?
Another 911 outgoing call at 1:11 a.m.
And then what's below? So there's a couple more 911 calls, and then we get the longest one being 50 seconds at 1:12:58. Is that correct?
No, the longest
No.
would be in 134 at
Where's that one?
2 up.
Oh, two up. There you go. 1:11 is the 1 minute and 34 second. And how many 911 calls?
I'm sorry, that is incorrect also. Go down to number 9.
Got a longer one at
Yes,
4:17. At 1:18.
Yes,
How many calls, have you listened to the 911 calls that were made by this defendant in this case?
yes, I have.
How many were completed?
I believe that I heard 2 separate ones where there was actually a dialogue or interaction.
Okay, so these other calls that we're seeing, is it your understanding that those calls maybe didn't go through?
I don't have any recordings of them, so all dispatch's activities are monitored and recorded.
Okay. And then we see at 1:15, who is the defendant calling at 1:15?
Dana Gardner,
And then also, that was at 1:15:07, and then 1:15:26, who is she calling?
the same person, Dana Gardner.
Do you know who Dana is?
I believe it's her sister.
Okay. And then after she calls her sister at 1:15, we have the 1:18, that's 4 minutes, and another 3-minute one, correct?
Yes.
Okay. Then I'm going to show you states 199H. So states 199H, if we look, it's one page. I'm going to point your attention to this position 4 on this report. What is position 4?
It's going to be an outgoing text message.
And who is it going to?
I believe, correction, outgoing, it's going to be not a text message. It's going to be a social media message,
Okay.
yes.
And who is that message going to?
The Emily, I-S-T-R-A-T-E,
Istreet
I-Straight.
is how I'm going to say it. Who is Emily Istreet?
I'm not sure.
Do you know the name of Lilia's daughter?
Oh, I knew Lilia Bocan. I was not familiar with the daughter's last name, yes.
Did you know that Lilia had a daughter?
Yes, I did know she had a daughter.
And it says this is on Facebook Messenger, is that right?
That is correct.
Could you read the message that the defendant sent to Emily Istreet?
David Barron, why is he paying for your apartment? A scam set up by Lilia Bocan. Your mother, all will stop.
And what was the date that that Facebook message was sent?
February 12th, 2025 at 1:39 a.m.
1:39 in the morning.
That is correct.
Then I'm going to show you 199N. It's also one page. I'm gonna zoom out so we can see it. So, what is 199N?
It's going to be more Facebook Messenger history off the device.
And who is this Facebook message sent to?
Lilia Bocan.
And if you could read the message that the defendant sent to Lilia Bocan on Facebook.
David Barron, did you scam him? That will all stop. We are getting married.
And what was the date and time of this message?
Delivered February 12th, 2025 at 1:40 a.m.
1:40 a.m.
Yes.
I'm going to show you 199O. $199.00 is a little bit longer than one page. I'm going to try and zoom out. What is 199.0 a report of?
It's going to be, the way it's broke up, the way the phone's categorized and celebrate, you can narrow down the things you want to search. This is going to be the notes section of an iPhone.
So like in your little notes app where you can type notes, that's what this is a report of?
Yes.
So this first one, I'm not going to have you read all of them, but I kind of just want to go over some of them. So like, for example, this first one is on January 21st, 2025 at 1 a.m. If you could, if you don't mind just reading this first note at the top.
Okay. I was very hurt when I found out you were not truthful with me. I don't understand why you could not come around or come to me and be honest. I know it's hard sometimes to trust someone, but I want to be your safe place. I do not want to judge you. However, in a relationship, there has to be trust, boundaries for both of us. I love being with you. You're like my best friend, my lover. You're my heart. Never forget that you are my heart and my love. Please let me know when you're ready today to be honest with me, and we can begin to heal our relationship. I believe we are worth working on.
And what does this column right here indicate?
It was deleted.
And are these, all of these notes, are these all from the defendant's phone?
Yes, this report is, yes.
Okay. So below that, it looks like another note. Does this look like the same thing as what you just read previously?
So if you scroll up, I'll explain this to jury what you're looking at. See, right on the timestamp,
Here.
you look down, you'll see the date and time, you'll see creation time. Then you scroll down to the next one, and you'll see a different date. So it was January 24th, 2025 at 12:50, but it's different because it's a modification time. That just means that note was changed somehow at this time.
And then was this, so this is all the same note. This is when it was created, was January 21st at 1 a.m. And then it was modified January 24th at 12:50 p.m.
Yes, that's what the report indicates.
And so when they both say trash, is that because it's the same note, just created and then modified?
Yes.
Okay. So then at January 30th at 3:39 a.m., there is a much longer one. I'm not going to have you read all of that, but if you could maybe just read just from David until the bottom of this page.
Just the first page?
Yes.
First section? Okay. David, appreciate you asking, but right now I have to value me. I offered you grace and forgiveness because I love you so much, and I was led to believe by you that I was the love of your life. However, when you chose her, you gave up your right to me. I have survived before on my own, and will do it again. My dream with you has died, but my dream to live on the lake, my dream with you has died, but my dream to live on the lake, see my daughter get married, see my children, and hopefully soon grandchildren, enjoy this home will bring me so much joy. I deserve to have a beautiful home and life, and to be able to relax. I deserve to have someone that loves me and values and respects me. I want to buy a boat soon and live the rest of my life here.
If you could also just maybe read this first sentence right here.
You do not have to pretend that you care about me. It is clear as day that you don't. Please do not contact me except through emails. Don't ask me how I am. Just stick to business.
And so it goes on. What's your understanding of, like, when you read these notes, what was your understanding of what these notes were?
Either some type of rehearsed text message she wanted to send, or there's even a few that almost seem like, diary entries.
And so, scrolling down to, we also have another one on January 30th at 8 a.m. If you could just read just the first paragraph so we can see what this one's about.
So do you want to go just to amazing?
Just to, yeah, amazing.
Okay. It's sad I don't even know what to say to you anymore. Of course, I would love to see you and have you hold me and take care of me. I try not to think of you, but you are everywhere, in my past, my present, and I thought we had a beautiful future together. You had become my best friend. You made me smile, laugh, and love like never before. When we made love, I felt like we were one. Our kisses were amazing.
So then this one continues. And then this is at, so this says so this one said created time was at 8:03. Below that we have the same date, modified time at 2:12. Is this that same note but has been modified?
I believe so.
And has this note also been deleted?
Yes.
So then we have a new one on February 2nd at 8:04 a.m. If you don't mind reading, if you don't mind reading this one, sorry.
Whole one?
Yes, please.
Okay. Good morning. He came to St. Simon's this weekend to explain. They have been texting and communicating. She told me that they were married all year. I asked him about that, and at first he did tell me the truth, and then I told him, she told me. I told him that is an affair. Apparently, when she flies to New York, when she comes to Atlanta, he sees her. I do not understand why he became involved with me and bought a home with me if he was involved in a relationship. I am still deeply hurt and in shock. She is on Facebook as well as her daughter, and they look happy and very well taken care of. I asked your dad to see his text messages, and he would not let me hold his phone. He became very angry and left. I love your dad very much, but I cannot be in this relationship where there is no trust. And so many lies and betrayals. He is living two separate lives. He has broken my heart. I can tell you more, but I'd rather not on this text. He not drink alcohol on Friday. We stay in, and I did not have in my condo. I did tell him that I'll talk to my sisters, and he was upset and angry with me after he had drinks. When we went out for dinner, he is embarrassed because of taught him my sisters. He became very, very angry and loud because I told him that she was using him. This is just a huge nightmare, and I feel like I'm in the middle. He cannot take confrontation and left last night. I guess he stayed in the hotel. He said this was all my fault. I do not understand. I fell in love with a man that I thought was completely single and in love with me. I feel like I do not even know him. He told me this weekend he was going to end it with her because he loved me. When he is drinking, he is I believe it's supposed to be is, a different creature.
And this note mentions your dad, so, like, she's saying your dad. What's your understanding of who this note?
This is probably she wrote it in notes, composed a text message in notes, and probably going to send it to one of his sons. She doesn't address either one, so I don't know.
And at 8:04 a.m. on that same day, we have a modified time. Is this that same note that she has edited?
Yes,
And has this note also been deleted?
yes.
At February 8th at 3:22, we have another note. I'm not going to make you read the whole thing. If you could just start here to the bottom,
Okay, so here too, okay.
where it says your dad told me.
Your dad told me he has talked to Lilia several times regarding stopping payments to her in the apartment. He tells me she does not understand and is confused. I told him she has been manipulating him. I'm afraid he does not have the heart to remove the daughter from the apartment. He feels something. They are scamming him. She texted me to go away. I'm rooting everything. She is smarter than your dad wants to believe. You have to handle this for him. I wish it would end and go away. Thank you.
And then February 10th at 5 a.m., it looks like that same note was modified.
Yes.
Then we have February 15th at 4:50 p.m., another one that starts with David, and then it's a pretty long one. I won't have you read it, but was this note any different than any of the other ones that you had read?
This was modified, but, it was modified, so it's previously in there, and I would have to go,
So this one was modified from, if we scroll back up in the exhibit, right here, from the one that was created
Yes.
on January 30th
I
at
believe so.
3 a.m.
I believe so.
So if we scroll back down, that January 30th one was modified on February 15th.
Yes.
Okay. Then we get to February 17th at 6 p.m. If you could just read the first paragraph up until up until here.
Okay, just stop at 3.
Yes.
All right, can you go up just to,
Oh, I apologize.
there we go. All right, it says keep, no phone call, very rough, hearting impaired. I remember I realized I was going the wrong way and I pulled over to the right. I had a few drinks earlier, about 6:30. I think the last one was maybe 12 o'clock. I took my medication, progesterone, Lexapro, and a half a Zolpin around 2 o'clock. We've been watching a movie and I was headed to bed. We've gotten in an argument and I decided I couldn't sleep, so I would get up and leave to head back home because I had a lot of work to do at my office. I left at 4, but I decided to leave at around 3.
And do you remember the date of the DUI arrest that she had?
Not off the top of my head, but this, yeah.
Does it sound like does February 16th sound like around the time where she was arrested?
Probably she said a week before, so a couple weeks before, but I have the case number, but I don't remember the date of the report.
And is this, I'm not going to have you read all the rest of this note, but what is she talking about in the remainder of the note?
I believe it's notes about the DUI arrest.
So this note is like the DUI arrest.
Yes.
And earlier you mentioned some of these notes read more like a diary entry. Is this one of those notes that you
Yes.
were referring to?
Yes.
Then also on February 17th, it's modified, and is it that same note that's been modified?
It begins the same, so I would believe so.
Then we have a new one on February 22nd at 9 p.m. that was created. If you could just read this first paragraph.
The secret you hid and the lies you continue to keep playing on my mind. The overthinking, the unanswered questions, the silence, the absence of effort, the refusal to communicate. Your actions, or lack of, spoke louder than any words ever could. I am looking at your behavior, your silence, your refusal to give me peace and security. You are not willing to fight for me or take responsibility.
If you could actually just read the remainder of that note, since it's not too long.
Your continued silence, your need to protect Lillian and provide for her, to care for her, well-being shows me I am not the woman you're looking for. It is obvious who you love and care about. I need to move forward. Since all of this surfaces, I question your commitment, love, and future for us. Lillian is a lucky woman to have your heart and loyalty. I deserve someone who makes an effort to respect and care for me, not silence. I need someone that makes me feel loved and safe.
And then right below that, we have the same note that has a modified time of 9:57 PM on that same day. And then February 23rd at 5 PM, if you could just start reading at the top, and actually, we're gonna skip. Can you start reading right here at after?
After movie, he began watching the sports news, and we had argued earlier, so I went to the bedroom and packed my belongings. Because I was planning on leaving around 4 a.m., because it takes about 5.5 hours to drive home. I was headed to go to my office. I had to complete my my taxes and medical insurance claims for patients, and prepare documents because I am in the process of trying to sell my dental practice. Also, to prepare my home for showing, and the following day around 1:30, because I am selling my home as well. I crawled in bed around midnight, and David had fallen asleep watching TV. I got up and turned it off in the fireplace, and David woke up. He headed to the bedroom, and I started talking to him to solve argument he did not want to discuss, and he headed upstairs around 1:30 a.m. I laid in bed for several hours and could not fall asleep. I read a few articles and organized my thoughts in my journal. Around 3 a.m., I decided to leave an hour early, packing my belongings and put inside my vehicle. When I came back inside, David was awake and on the stairs. We talked for about 20 minutes. I left and headed home.
And then on March 1st at 8 PM, it looks like that note was modified.
Correct?
Lastly, I want to show you State's Exhibit 199R. What is State's 199R?
This report of searched items on the phone,
Like searched where?
internet items.
Like searched on the internet?
Yes.
What's the date of all these searches?
March 7th, 10:19 p.m., March 7th, 10:19, 09, 10:19:47, March 7th again, 10:19:54, and same date, but 10:20 even.
So all of these four searches were searched on March 7th at 10:19, all within a couple seconds of each other, and then 10:20, about 6 seconds after the one before it.
Excuse me, yes.
And what are the searches that the defendant was searching in her web browser?
It's titled the Sheriff's Office, County Jail in Hall County, so I believe in layman's terms, she's searching the Hall County Jail.
And she's searching the Hall County Jail 4 times. Are any of these searches deleted?
The one on Safari,
And so this is March 7th at 10 PM. What's your understanding of when 911 was called?
March 8th, approximately started around 1:11, I believe.
So about 3 hours prior to the 911 call, these 4 searches were done in the defendant's phone?
Yes.
Thank you, Investigator Mefford. I don't have any other questions. Yeah, I'm gonna put them up there, or do you want them? Sure. This is all of them. Here you go.
Well, we're going to start exactly where she left off, okay?
Okay.
Is my pen up there?
Yes, thank you.
Is that right?
That is, yes.
The orientation?
Yes. Okay. Ryan.
Can you sit on top of it?
I want to be able to see the whole thing here. All right. We know the 911 call came in, I think it was 1:10 a.m. actually, the first one, right?
Somewhere around there.
On March the 8th. And what we've got here is things saying searched items, right?
That
Over
is
here
the
in this
type,
column.
the type, yes,
Yep. One of them is a Safari search.
yes,
Safari is a way to search things on a phone. It's a web browser, right?
yes,
iPhone is what she has.
yes.
Okay. We've got a Safari search, 10:19 p.m., according to this record, right?
Yes.
Now, these all say knowledge. Do you know what that means when we see source knowledge C?
I've had the conversation with Lieutenant London, but not off the top of my head.
Okay. Okay. Well, and I want to make sure we got this right, because I think you said she searched for it 4 times.
Well, it's in there 4 times. It's on the report 4 times. Yes.
You're not telling these folks that you're a computer forensic expert.
Nope.
Okay. This is a report that was done through Cellbrite. We know Safari was a search, and you're not certain what knowledge means.
No.
Okay. Now, this thing says deleted, yes, and it's got a red on it, right? And are you saying that that means that she deleted that out of her search history?
I would believe so. That's, yes.
Why are you saying that? Just because the red yes is there?
Typically, I mean, I would have to run a trash report to confirm, or the deleted files, but
But you're not a forensic expert. You haven't done any of that work. You're just, it says yes in red, and that's why you're
Yes.
saying deleted.
yes.
All right, let's talk about these notes, okay? I think that's 199O. Am I right about that? Is the notes O?
Yeah.
Yep. Let's talk about 199O. First of all, just to restate it, when you have an iPhone or any kind of phone, you can open it up and there's something called a Notes app.
Yes.
You can take notes in your phone. Everybody knows this, but you can take notes in your phone. You can load them in there. You can save them. You can delete them. You can amend them, all that stuff. Right?
Yes.
And it can act as a journal. Could be, just be note, right? True?
Yes.
Okay. Great. Let's talk about the entry from 2/2/25. This is the one, yeah, 2/2/25, where it seems like we think maybe this is a note to one of the sons he's working on. Maybe a text she's going to send later or something.
I don't know who this was intended to send for, but I could see where it'd be a text.
I thought you said it was presumably to one of the sons.
There was another one, I believe, that
Okay.
she indicated.
I'm going to hand you the document and you can find it for me. The one that we think is the note to the son.
Yeah. You want that?
It's 2/2/25.
Yes, I apologize. I did not see that. I love your dad. That's what indicated that.
Okay, so that was the one?
Yeah, I believe so. I just didn't see the I love your dad part that indicated that.
Okay. We'll put it back up in the overhead for everybody. Now, what was it that had just happened on July the 31st and February 1st in St. Simon's Island? What had just happened?
The unfounded domestic dispute.
The unfounded domestic issue had just occurred. The unfounded domestic issue with the softball-sized injury to the back of her head. Yes, sir?
It was never stated that it was just unfounded as far as I know. I was not there, so I can't testify to it.
Well, you just said unfounded.
That's what they no arrest was made, so.
It had just happened on July 31st. January 31st. Thank you. January 31st in St. Simon's Island, this unfounded issue with the softball-sized injury. And she is apparently planning some note to his kids, right? It's within 48 hours of that event,
Okay.
right?
Yes.
Okay. And she's telling him he didn't drink alcohol Friday. We stayed in, and I did not have in my condo. She's telling him he's done the Lilia stuff she's complaining about, right? But she's not planning to tell him anything about this injury to her head or this problem, apparently, right?
She didn't mention it.
That's right. Didn't mention it. Let's talk about the DUI now. Okay? My hand is to you.
Okay, thank you.
I want you to find that DUI note. Let's look at the 223 DUI note. Remember, the first DUI note was 21725.
Yes.
Let's look at the 22325.
Okay, I'm on that note.
Okay, you got it? May I approach?
You want me to fully read it first, Ken, or? you wanna-
Starting with this paragraph here. Okay? After the movie, he began watching sports news. We had argued earlier, and so I went on to the bedroom and packed my belongings because I was planning on leaving around 4 a.m. because it takes 5.5 hours to drive home. I was headed home to go to my office. I had to complete my taxes, medical insurance, claims for patients, and prepare documents because I'm in the process of selling my dental practice. Also, to prepare my home for a showing the following day at 1:30 because I'm selling my home as well. I crawled in bed around midnight and David had fallen asleep watching TV. I got up and turned off the TV and fireplace and woke David up. He headed to the bedroom and I started talking to him to solve argument, and he did not want to discuss, and he headed upstairs at 1:30 a.m. Upstairs at 1:30 a.m. I laid in bed for several hours. I could not fall asleep. I read a few articles, organized my thoughts in my journal. Around 3 a.m., I decided to leave an hour early. I packed my belongings and put inside my vehicle. When I came back inside, David was awake and on the stairs, and we talked for about 20 minutes, and I left for home, to head home. Right? That's what it says.
Yes.
And this is taken as a note. Who is this for?
There's nobody addressed.
There's no one addressed. She's taking this note. Why is she working on this version?
Don't know.
Why does she want to remember this version in this particular way that it's so important that she takes a note and saves it in her phone? Okay, don't know.
I just know what was on the device. Yes.
Doesn't it seem strange that a person would have to take notes about what happened in the real world in order to remember them? Doesn't that seem a little strange to you?
Is that a question?
Yes, sir.
People do all sorts of things with their phones. I can't comment on that. I can't say it is.
Okay. We'll talk about this a little bit later on, okay? I want to talk to you now first. Will you label those up for me?
Yep.
First, I want to talk to you while we're getting some pictures together about the body camera from Richard Thomas,
Okay.
Officer Thomas. It was in State's Exhibit 6, okay? Judge, I need to plug this. No.
Yes.
Is there a button you have to hit? Do you have to do anything? Would you hit it? I'm sorry.
There is, and I did.
Okay. It might be doing that thing again, so I may have to close out of everything because we are up. This is State's Exhibit 6. It's been dragging. We're hitting like that.
Like the TV is like a double screen, so you pretend like it's a double screen, you have to like move it to the other screen, you know what I'm saying? Yeah, try dragging it like up or to the left, or
Okay.
maybe not. That's all I have to do, I have to like drag it to the left, get it on this TV.
Let's see. Doesn't look like any of the TVs are on. Let me close out of it, Judge. This is what did it last time, so.
So I would anticipate that this witness will, the cross-examination will go on for a while. Let's take a break now, and then we'll come back. 15 minutes, please.
I had to close out of it completely last time, and then it didn't. It's the red light.
They're just lit up. Yep. All right, y'all can be seated. We're in recess, 15 minutes. Thank you.
To like,
What is going on here?
yeah, I don't know if it's up, down, left, right.
Just a quick note.
There you go.
Did it?
Yep.
I believe there's another trial going on, so I think the bailiffs may be using some of the hallway. So you potentially may be interacting with jurors. Do not interact with jurors. Thank you. All right, welcome back. Thank you so much. Please be seated. We'll continue with witness examination.
Okay. I think you testified on direct examination that you'd watched, I think you said he'd watched Mr. Deputy Thomas's video many, many times.
Yes, I have seen it.
That's State's Exhibit 6, Judge. It's been previously tendered and admitted. I want to direct your attention to the part where the EMS folks have shown up and they're dealing with Ms. Mericle and checking her vitals, okay? And Chris, if you could start it at 44:46 on the video.
44:45.
Sorry, 44:45.
I know you guys are taking essentially rights from her, or like you're taking over. She does probably need to get checked out. So blood pressure's up. She's dealing with a lot of stress. Just mental health evaluation, all that stuff. We're gonna recommend you.
EMS is on scene. They're evaluating her. They say she's got elevated blood pressure, right? Correct?
Yes,
She's under a lot of stress
yes.
and needs a mental health evaluation on some stuff.
Just mental health evaluation on stuff.
Roll it to 46:19, Mr. Van Rossum. That's 46:05. That's 46:45. There you go. That's good enough. 46:15, Judge.
I'm out here with you. I can't answer that question for you.
How did this happen? I was so scared. He like turned into somebody I didn't know.
First thing she's asking is he okay? They don't give a response. Then she says, how did this happen? I was so scared. Right? Correct.
Under this single contexted line, yes, that is what is said, which contradicts.
We'll get into that. Go ahead and roll it.
Has anything like this ever happened before? Where he's gotten violent with you in the past?
The question is asked to her if he's been violent with her in the past. She doesn't say anything, but what does she do?
I was reading.
Okay.
I'm sorry.
Back it up 10 seconds, Chris, and let's roll it again.
Where he's gotten violent with you in the past?
She doesn't verbally say anything, but what does she do?
She does give a head nod.
A head nod to, has he ever gotten violent with you in the past?
Yes.
Yes. At this point, she keeps asking, is he alive? Is he dead? Is he alive? Is he dead? You'd agree with that?
She keeps asking for his status
That's right.
throughout the entire investigation, yes.
So she nods to prior violence. Do you agree with that?
Yes.
Doesn't say it, but she nods to it. Correct? Correct?
Again, yes.
Okay. Go ahead and roll it again, Chris.
How did this happen? Like, what are y'all saying? What are y'all saying?
Nothing. Don't worry about it.
What are Please tell me he's still alive.
We don't know.
We don't
We've
know.
been out here with you this
Okay.
entire
What am
time.
I gonna tell his kids?
But
I've got to call his kids and tell them he's at the hospital.
She asks if she can contact his children. That's obviously Colt and Evan, correct?
Correct?
Let's roll down, Chris, to 4842, same page.
Yes, sir.
That's good enough. 4839. Go ahead. 4839, Judge.
4117, all units, over.
What do I do?
Central radio, extension.
I should never have got my gun. I thought he was gonna kill me. He said he was gonna, he put it like towards my mouth, said he was gonna shove it down my throat.
I thought he was going to kill me, correct?
That is what it said at this time.
The next thing is, he said he was going to, he put it like toward my mouth and said he was going to shove it down my throat. Correct?
Yes.
Chris, 5044. 5044. That's good. 5040, Judge. 5040.
I kind of feel for a pulse.
I tried to feel for a pulse, correct?
Yes.
Go ahead and roll it, Chris.
40, could you give me? 02340, opening 02340.
How much blood? Why did I go get my gun? You can't tell me who's getting. No, don't go to sleep. I should have just left. I told him I was gonna leave, but I was scared because the last time I left, got in a fight, I got pulled over, and they were not. I have a hearing.
He told me don't go to sleep, correct?
Again, according to this snippet, yes.
I told him I was going to leave. She says, I should have just left. I told him I was going to leave, but I was scared because last time I left, we got in a fight. I got pulled over, and then she sort of trails off. Correct?
That's what it says here, and that's what I heard. But it's,
That seems to be talking about the DUI night, right?
Possibly.
Well,
No. This is completely out of context, just one line snippet, so
I
I have to go
understand.
back through.
but she says, I got pulled over when she left.
Oh, the last time.
Yeah.
Yes.
Yeah.
Yes.
But the DUI notes in the phone, the DUI notes in the phone that we just looked at, that she'd been practicing, they say he heads upstairs 1:30. I couldn't fall asleep. I read a few articles, organized my thoughts in my journal. Around 3 a.m., I decided to leave an hour early. I packed my belongings and put inside my vehicle. When I came back inside, David was awake and on the stairs, and we talked for 20 minutes, and I left to head home. Right?
I think you're merging two things. I think that is solely about the DUI night. I think this, she's trying to talk about this night, but ends with the reason I didn't leave was I got pulled over.
Okay, so you don't think she's talking about the DUI night here?
Not this entire sentence, no. I think she's trying to use that as an excuse that she did not leave.
Okay. Okay. We'll keep working on that, okay? Let's go 53-55, Chris. You're good. 53-54, Judge.
He's a good man, he is. He just got mixed up with this. He was in a struggle. He just couldn't. And then I just told him that I was just gonna move forward, that I just couldn't deal with it. And he got so mad at me.
Pause. We hear this thing, we hear a lot, that she says he's a good man.
Mhm.
Right?
Yes.
And then she says, I just told him I was just going to move forward. I just couldn't deal with it, and he got so mad at me. Right?
That is what I'm reading out of this snippet, yes.
Well, that's what we just heard.
Yes, that's, mhm.
Put a little at symbol to save some space. Sorry. Go ahead and roll it, Chris.
I'm just told him if he wanted to be with her, he could. I told him I wasn't mad at him. I'm just tired. I just want to deal with it anymore. I just said if I started dating.
told him I wasn't mad at him. I'm just tired. I didn't want to deal with it anymore. Right? That's what she said?
Yes.
And then the next part is, he just said if I started dating, and then she trailed off. Correct?
Mhm.
Go ahead and roll it, Chris.
We had a nice night. He got mad. I told him that I didn't want this house anymore, that he told me he didn't want the house. He said, do you want it? I said, let's just sell it. And I told him, because he's been paying that woman in Romania money. And I just said, you can pay the rent for the next 6 months. And let's just not see each other, talk to each other, and let's just. And he said, if I moved on, he would kill me. And he told me to shove that gun down my throat.
The last thing she says is, and he said if I moved on, he would kill me. And he told me he would shove that gun down my throat. Correct?
That's what it said at this time. So,
Go ahead and roll it again.
I mean, I'm just happy. We're both good people. We're both good people. Sometimes things just don't work out. Oh, David. Oh my God, he's such a good guy. He really is.
We're hearing this statement again about what a good guy David Barron is,
yes.
which would seem to be inconsistent with, if I move on, I'm going to kill you. I'll shove this gun down your throat. Don't go to sleep. Right?
Yes, like I was saying earlier, a lot of the inconsistencies through the interview.
inconsistent. Right?
Yes.
These aren't the things a good guy does. These things.
The alleged things? No, they're not.
Go ahead and roll it again, Chris.
Oh, I know. He's a good. Oh my God. Oh. Oh my God. Oh my God. sweet things. I told him, let me sleep up there, you sleep here, because this door doesn't lock, and that door does.
Let me sleep up there because this door doesn't lock and that door does. Correct?
Yes.
And she means, of course, that downstairs master bedroom. Correct?
It can be assumed.
Because that one doesn't lock. Right?
Yes.
The bedroom that locks is upstairs. And she says, let me sleep up there because this door doesn't lock and that door does. Go ahead and roll it, Chris.
He told me not to close my eyes. I should have just got in my car and left, but I got that stupid device thing on it. Oh,
I should have got into my car and left, but I have that stupid device thing on it. Correct?
That is the statement again with, yes.
And you know from your investigation, what she's referring to is an ignition interlock device.
Yes.
The Porsche that she owns is fitted with an ignition interlock device related to the 215-216 arrest for the DUI.
Yes.
When a person has consumed any amount of alcohol and they get into a vehicle with an ignition interlock switch and they try to start it by blowing into it, it won't work. Correct?
Yes.
They're designed to not function if you've got alcohol in your breath.
Yes. I know.
And that's what's in her car.
Yes. Yes.
Now, 105-23, Chris. Up until 105-23, she does not know his condition despite repeated requests to find out what the condition was. But at 105-23, you would agree she is told, and we'll go ahead and watch it, then I'll finish my question, okay? You're at 105-18, that's fine.
If I should physically drive down there.
he was alive.
When they left here, yes.
Oh my God, thank God.
First thing now.
Okay, 105-23, thereabouts, she's told very directly, when they left here, yes, meaning he was alive. True?
That is what the statement is. Yes.
And you're not aware of a later statement by anybody until the one that you made
Yes.
in the interview room hours later, at the very end of the interview, telling her, close to the end, telling her he was deceased.
Yes, because like I said, the reason I did not tell her the whole time is I knew the emotional aspect of the interview would be over, as which it was.
You didn't tell her because you knew that the emotional aspect would end your ability to interview. right?
Yes, therefore the theatrics of it, yes, the up and down, up and down.
One 3258, Chris? Let's go 13758, I'm sorry, 13758.
When he got mad at me, I should have just left, but I was scared because the last time he got mad at me, and I left, and I was so upset.
This is again a reference to the DUI night, true?
Yes,
But it's not consistent with this note that we have in the phone.
no, but there's no time relevance of when he was mad. It could have been to the DUI, it could have been, that's the way I read this.
No, you just said this is in reference to the DUI. Earlier you said, I don't think she was talking about it, but you just said it was in reference to the DUI, what she's talking about here.
The statement earlier, I was referencing, I think she was talking about that night, but earlier about the DUI. This statement here, he got mad at me, I should have left, but I was scared, which was referencing this night here, what I believe. Because the last time he got mad at me and I left, I was so upset.
Yeah.
That was this time. But keep in mind, the statements are so inconsistent here because there's
Okay. We'll just agree that her version, if she's talking about the DUI, is not consistent with the note. True?
I cannot agree with that.
You think it is consistent with the note?
I think you're pulling two very different things and trying to make me agree to correlate on one thing.
What I'm asking you is the note consistent with her version of the DUI that she gives at least twice so far? And again, later, we're going to talk about it.
One note is a lot more detailed, the note that you're speaking of. These are just statements on the front porch that you're asking me to derive an opinion about when I cannot do that because she's talking about this night, then mentions other times.
Okay, all right. I want to talk to you now about the interview. Okay?
Yes, sir.
I think that is that's State's Exhibit, is it 1 or 2? What is your interview? States?
It is 219.
219. Oh, got it. Now we're going to have to get out of that, but I have to tell it to allow me to unplug it. I can't get it. I want to eject this one by going, can you get back on the screen and do it? Is it? You want to take out what's on the mouse now? Do I have to tell it to eject? There you go. That's it. And then we'll go 219. Good deal. All right. Let's go to page 6. Let's start at 3502. Don't roll it till I say okay. Thanks. I want to talk to you now while we're getting this going about your experience as a police officer and your training and all those things, okay?
What?
You would agree with me if I was to say this was your first homicide case
So,
ever been the lead on?
actually, when I was speaking, I was talking murder, not homicide. No, I've worked in voluntary homicide, stuff like that. I was thinking murder while we were talking. I've
You
had
mean-
time since then.
At this time, this was your first homicide/murder case that you'd ever worked.
Where the murder warrant was taken.
So that's a yes, correct?
Yes, as lead.
It's your first case on a homicide, and of course you rely on your training when you're doing that, when you're working a case. And you've had training dating back to 2013, when you first started as a jailer.
Yes,
And every year you go back for more training.
yes,
That's part of what it is to be a police officer.
yes.
And as far as training related to firearms, you'd agree you've got a lot of that.
Naturally, yes.
2016, you took the firearms and use of deadly force as a 4-hour course.
Mhm.
You took low-light firearm skills in 2016.
Should have done it every year, so.
Well, and we'll talk about that in a second, but you took shotgun as well, which is a separate course just about shotguns.
Yes,
Another firearms use of deadly force in 2017. Sound right?
is that the 1-hour course that we're talking, 2-hour course?
2-hour course.
Yeah, so that's the state required use of force class and annual qualification. It's going to happen every year, yes.
You took a 16-hour patrol rifle course.
Mhm.
You took another patrol rifle course for 2 hours that same year. Sound right?
If it's on my post, I'm sure it's correct, yes.
So I'll approach and show you just because I don't want you to guess, okay? May I approach witness?
So yes, there's been firearms training every year.
There's patrol rifle.
I mean, it keeps going, yes.
Oh, yeah, it does. And low-light firearms training again.
Mhm.
You took a firearms requalification for 2 hours in 2018. Sound right?
It's annual.
May I just stand up here so you can actually view the record, Judge? May I approach?
Here.
I don't want to, I'm not trying to hide something from you.
No,
I want you to-
Yes, it's annual qualification stuff. Most of that stuff is.
2 hours requalification in 2018, right?
Mhm.
2 hours requalification, use of deadly force in 2018. And then you got
Oh, yes,
ambush survival tactics, 16 hours in 2018.
yes,
Shotgun, 2 hours in 2018.
yes,
Patrol rifle, another 2 hours in 2018.
yes,
2 hours in firearms requalification, use of deadly force in 2019.
yes,
Advanced pistol tactics, 8 hours in 2019.
yes,
2 hour shotgun in 2018.
yes, yes,
2 hours patrol rifle requalification.
yes,
2 hours low light firearms training.
yes,
Then in 2020, we've got firearms requalification and use of deadly force, 4 hours.
yes,
2 hours low light firearms training. Right?
yes,
2020, 1 hour backup weapon training.
yes, that was qualification on the backup.
Still in we're in 2021, I'm sorry. Firearms requalification, use of deadly force, 2 hours.
Yes, annual,
1 hour firearms requalification, 2021.
yes,
1 other hour of patrol rifle qualification.
Mhm.
1 hour firearms training in 2021.
yes,
1 hour firearms training. It says not requalification, and also in 2021.
yes,
Then we're in 2022, another hour of firearms training,
yes,
and then a firearms requalification, another hour.
yes,
2022, still another firearms training for an hour.
yes,
Not a requalification, another firearms training, 2022 for an hour.
yes,
Another firearms training in 2022,
yes,
not a requalification. Then another hour in firearms training in 2022. Then 8 hours in tactical firearm skills in 2022.
yes,
Looks like you took SWAT training twice, which was 8 hours apiece for 16 hours.
those aren't just firearms, they're tactics also, but yes,
Okay. Low light firearms training again, 1 hour, and another low light firearms training 1 hour in 2022. Then we're into 2023, another firearms training, not requalification, 2023.
yeah, I just want to, it's my post record, I was just curious about one thing while you're going through this.
I'll let you handle it.
No, that's fine, you're good, it's 2:30, yes,
Still on 2023. Firearms requalification, 1 hour. Correct?
yes,
Then another firearm training, 2023.
yes,
Then an hour on use of deadly force,
yes,
16 hours on SWAT training in
yes,
2023. Another firearms training in 2023 for an hour. Then another hour in firearms training in 2023.
yes,
Then another hour in firearms requalification.
yes,
Then you took combat shooting skills for an hour.
yes,
Then backup weapons qualification for an
Yes.
hour. Then firearms requalification for an hour. Then another low light firearms training for an hour.
yes,
And then subdued lighting firearms requalification for an hour.
yes,
Then we're a patrol rifle qualification for an hour.
yes,
Backup weapon qualification for an hour.
yes,
And another 8 hours on use of deadly force.
yes,
Now we're into 2024. We got 1 hour on firearms requalification,
yes,
1 hour on combat shooting skills,
yes,
another hour on low light firearms training,
yes,
another hour on subdued lighting firearms requalification,
yes,
another hour on patrol rifle qualification, and
annual qualifications, yes,
then another hour on shotgun qualification,
yes.
and then 12 hours on use of deadly force.
Okay, yeah, that's not technically firearms, but
Okay.
yes,
Okay. And then an 82-hour firearms instructor course
yes,
at UNG.
yes,
Now we're into 2025. Firearms requalification, 1 hour. Subdued lighting firearms requalification for 1 hour.
yes,
Low light firearms training for an hour.
yes,
Another 4 hours low light firearms training. 1 hour backup weapon qualification.
yes,
8 hours on tactical shotgun. Correct?
yes, I was thinking about the course, yes, I believe that was
I don't know how many hours that is, but it's a lot.
there's, in perspective though, there's a lot that was skipped over in that as far as other training diversities.
Exactly. I want to talk to you about the number of times and the number of hours you've taken on domestic violence investigation. Okay? We see 1 hour in 2016. See that?
Yes. Mhm.
See that?
I was just looking above it to make sure, yes.
And we see 1 more hour in 2021.
Mhm.
2 hours total, correct?
I guess it seems like I've had a lot more than that, but
Okay. We'll look through it.
no, I'm good.
You are on now your first murder case where you are the lead detective. You have the suspect in the room with you, and you know she has made statements about being afraid that he might kill her. She has nodded to being so scared, whether there was prior violence. She said yes, or nodded her head. She said, I thought he was going to kill me. She had said that he said, don't go to sleep. She had said, I was going to leave and I was scared. He got mad when I was going to move forward. And if I moved on, he would kill me. He would shove that gun down my throat. She's asked if she can sleep in the upstairs room that locks, and she's expressed concern about being able to leave in her car. And she's been checked out by EMS, right?
Yes.
She has elevated blood pressure, and they're telling the officers there, she needs to go to the hospital and get checked out.
But she refused.
I'm sorry?
She refused.
Correct, she didn't want to go, right? Nobody's fault. She didn't want to go. True?
Correct.
The thing she wants to know more than anything is whether he's alive or dead. Agreed?
She keeps asking.
She didn't ask for anything more than that. That was the number one request, right?
Yes.
And she comes into the interview room with you, and you don't want to give her that information. You said, I didn't tell her because I knew the emotional aspects would end the interview.
Yes, the theatrics of it, yes.
And then, go ahead and roll it. We're starting at 3458.
David's, do you know his? You don't know his passcode?
You don't want me to know his.
Okay, all right. So, you're here, and it's very important to me that you're here. You've already said some stuff about why you're here, and that really has been interesting. I really want to know everything. But before you can tell me that, because I have you here, and you don't know the way out of the building, like I said, I want to read something to you, okay? But I just want to preference what you have to tell me is very important, okay? So, it's basic stuff you've heard before. You're not under arrest. It's just circumstantial stuff, okay? You have the right to remain silent. Anything you say can be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any question if you wish. You can decide anytime to exercise these rights and not answer any questions or make any statements. But I'm going to preference that with what you have to say is very important to me. I want to know.
So should I get a lawyer?
Right now, you have no reason to have one. But what you say is very important to me.
Just, I told you, it's just been a bad experience here since I moved here.
One thing, will you just sign right, place your name right here? Just write your name, however you write it. And then just your initials. I have a pen for you. Hold your glasses. Just initial those. That's each bullet point. You can reread it. Same thing I said. If you place your name on the bottom. Yeah. Thank you. And then,
As a police officer, one of the things that's important to you is people's constitutional rights.
Yes.
You know that those are important and they're things that you take seriously.
Yes.
you want to make sure that everybody who comes into an interview with you knows what their rights are
Yes,
and that they have been told what their rights are
yes,
and that they're given an opportunity to exercise those rights.
yes,
And your sheriff's office, in addition to the constitutional rights, has rules about advising people about their constitutional rights.
yes,
And you have a pre-printed form that you're asked to use in these sorts of situations.
yes,
Right. The form has each one of the individual rights
yes,
listed
yes, we've seen the form.
and a place for everybody to initial
Yes,
for each individual right, correct?
yes,
And then at the bottom, it also provides a place for a signature. Correct?
yes,
And there's a space for you to initial all the rights that shows that you understand them. Correct?
yes,
And you even encouraged her to initial those things, right?
yes,
You said, go ahead and initial those, indicating you understand, right?
yes,
And then you just handed her the form and said, just go ahead and sign, just sign right there at the bottom.
place your name, yes.
You know that there are things during an interview like this that a lawyer could be of assistance to a suspect with. True?
Yes, mhm,
That's why the rights are there. You can have a lawyer with you while you're being questioned. Right?
yes,
You know that if a lawyer was to come in there, they might first of all say, this is not a person in an emotional state to be interviewed right now. True?
hypothetically in that, yes,
Hypothetically, yes. They might say, hey, have you already been to the hospital and found out that this man is dead before this interview starts? They might find that out and tell her, hey, he's dead. This man is deceased. They're investigating you for a murder. Right?
yes, I mean,
But you didn't want her to have that information because you knew the emotional aspects of it would end the interview. Right?
I'll just answer the point blank question without any rebuttal, but yes.
If somebody is living in absolute terror of someone else, and they believe deep in their heart that this person is still alive, do you think that they're going to tell you all the things that he's done to them in an interview like this?
I mean, Judge, I'm gonna object, that calls for speculation. I don't even know how Investigator Medford can be answering these types of questions. He's asking for Investigator Medford to speculate about what other people might be thinking or how other people might react in a situation.
It's not speculative.
So,
I'll sustain the objection, but I'll allow you to ask it in a little bit different way.
You wanted to get information from her that was correct, didn't you?
yes,
You wanted to get information that was truthful, right?
absolutely,
You wanted to make her feel comfortable in the interview. You said, use the word rapport earlier, remember that?
yes, and even had a female in there.
Even had you a female in there
Yes,
to make her feel comfortable, right?
yes,
So that you could get accurate and correct information, right?
it was a hope.
Yes. If someone's afraid, they may not tell you the truth. You would agree with that?
Objection, speculation, calls for speculation.
Overruled.
I would say in cases, but I've also seen the other way. It goes both ways. I cannot hang on that statement and give you an accurate answer.
You can't give me an accurate answer.
I can see where somebody would, but then I can also think of instances where somebody does tell the truth. So it's speculate, yes.
Okay. Even when somebody's terrified of someone, you've had situations where they've told you the truth. Is that what you're saying?
Re-ask that question.
Even in situations where someone's terrified of another person,
Yes.
they've still told you the truth.
Yes.
And that's true in
Okay.
every case?
Well, we'll go to this. Look at the crimes against children cases. These kids sexually abused by people in their household, they still come forward and tell the truth.
Mm-hmm.
You know, they're terrified. There's a risk they have to go home with these people.
Well, that's pretty interesting now, isn't it? Because usually what they do is they say maybe one thing. They call it an outcry, don't they?
Initially, and then we go to the forensic interview.
Yeah, initially they just say one little thing, and then they have to go and sit with a psychologist in one of those rooms that has all the pictures all over the wall, right?
No, incorrect.
That's
The
not
forensic
where they go?
interview is not a psychologist. She can be trained in psychology, but they're just,
Okay.
I mean, I'm just telling you from the Edmonds Telford Center, and it's not a room with pictures. It's,
Don't they tell you that disclosure from a child is a process, meaning you only get a little bit at the beginning, and then over time it gets more and more and more?
yes.
Right. You might get a little at the beginning,
Mhm.
even though they're in a room safe, but over time, they tell more and more and more and more, right?
Yes.
Why did you think she wanted to know so badly that he was alive or dead?
Truthfully,
Yes, sir.
because she had altered the scene. She was trying to get with a story to stick with, and she could not make up her mind of what she was going to say.
She had altered the scene. She was trying to come up with a story to stick with. And whether he's alive or dead changes how she's going to tell the story.
Believe if it's her word against somebody else's, yes.
It might change what she tells you about what he had done to her. Would you agree?
Hypothetically.
Hypothetically, for sure. Well, let's just start. Let's just go right into the interview and talk about the very first thing that she starts telling you about. The very first thing is the DUI arrest, right?
Mm-hmm.
Go ahead and roll it.
Well,
Bad experience.
Well, it was Valentine's weekend, and we got in a fight about the same thing that we got in a fight about tonight. And I ended up getting a DUI. I left. We got a big fight, and he told me to leave or he was going to hurt me. And I tried to talk to him and tell him I didn't want to go and just let it be. And he sat on the steps and told me to go. And I did have some drinks that night, but it was like 6 something, because we'd been working all day. I fell asleep about 5, and I had like a drink at 6 after I didn't drink it all. Then we went to dinner, and then I had about a drink and a half there, and we went home. And then we watched a movie, and the movie probably lasted until like 11, and then he fell asleep in the chair. And I got up to my medicine at night, my hormone medicine, and my pray, and I took half a Benadryl, and then I laid down, and I couldn't go to sleep because we had a big fight, and then he came, after I got him all that, he came in there, and we got in a huge fight, and then, like he did again, he was going to go up the stairs, and so I went upstairs. He said, I laid there for about 3 hours. I couldn't go to sleep, so I thought, I was gonna go on to St. Simon's, because I usually get up I usually leave between 3 and 4 anyway. So I got up, got dressed, got all my stuff and put it in my car. And then I went upstairs and knocked, he had the door locked. I knocked on the door and I said I was leaving, and then I got the rest of my stuff and put it in the car, because I walked back in and I was gonna tell him goodbye, and he was sitting on the steps, on the second flight of steps. And he said, good.
This sounds incredibly close to the DUI note that's in the phone. Wouldn't you agree?
May I see them?
Yeah. I'll tell you what, I'll read it to you. You tell me, okay? David had fallen asleep watching TV. I got up and turned off the TV in the fireplace. David woke up. He headed to the bedroom, and I started talking to him to solve the argument. He did not wish to discuss, and he headed upstairs around 1:30 a.m. I lied in bed for several hours. I could not fall asleep. I wrote a few articles and organized my thoughts in my journal. Around 3 a.m., I decided to leave an hour early. I packed my belongings and put them inside of my car, my vehicle. When I came back inside, David was awake and on the stairs, and we talked for 20 minutes, and I left to head home. Pretty close.
Like it was practiced, yes.
Pretty darn close. The rehearsed note in the phone sounds almost identical to what she tells you in this interview. What do you make of that?
You're the one that said rehearsed. She said it quote for quote back to me, I guess.
Okay. Let's go to 4247, Chris. We're at 4246.
And he was, we're fighting about, when I met him in April, I had just broke up with a boyfriend like in February or whatever.
Are you at 4247? Oh, I think we were, come back a little bit further. Just a little bit beyond 4247. Go to 4240 if you would. 4240. 4234.
That was not good. So I had to go today and get a provisional license. I have a
This is, we're looking at page 8 on the transcript you have.
I'm looking for it, yes, sir.
It's that first full paragraph with her, okay? She says she has to go and get a provisional license that day,
Yes.
correct?
Yes.
And this would appear to be in reference to the ignition interlock license again?
Yes.
And just so the members of the jury understand, we've talked about this a little bit, but if somebody gets a DUI charge and has to suspend a license, they can go and get an ignition interlock permit, right?
It's something through the courts, not through the sheriff's office, so.
Yeah, I know you guys don't hand them out, but it's DDS that does it. Does that sound right?
Yes.
Okay. Well, the point is they don't have their original license Sorry.
That was my error. It'll come back on.
All right. I didn't know if we were ending early.
It'll come back on, hopefully.
When you have a provisional license, meaning an ignition interlock license, you're permitted to drive cars only that have interlocks on them.
I'm familiar with what the interlock system is, but I'm also familiar with the provisional license such as work, school, medical, stuff like that. I'm not familiar with the actual license.
Okay. As you sit here today, do you know whether she had actually gotten an interlock permit that morning or not?
I know there was interlock in her car.
Okay. Meaning in the Porsche,
That is correct.
not in the Kia, which
Don't
is
believe so.
Mr. Barron's car.
I believe, yes.
Okay. Let's go to 4819.
Where?
19,
Did you skip?
4819. 4819, if you can.
42.
Try to roll that back manually. I'm trying to get to 4819, so you don't have to, but I don't know how to. You can help us to make sure it's done. You're at 4823. You can see that, you don't need to tell you. From here? You can try from there. We'll see how we do. 4823. It's definitely not in violation. You're
Yeah, and then pause it and unmute.
.4813 on mute, Judge, until 4819 will unmute.
He hit me right across here. And then he took that gun and put it right. He said, I'll shove this down your throat. And he told me to get out of his way. He told me, don't go to sleep. No, I said, I'm leaving. But I was scared to leave because I had a couple drinks. I mean, I've been intoxicated, but I had a drink and then I had one drink and then I was still drinking a drink when all this happened. So I went and got my gun, and I don't know why I got my gun. I was going up the stairs. He said, he said, I got your phone and your journal, and I was going up the stairs to get them. Is he okay?
I will learn that here in a minute.
All the sounds are stupid.
It's okay.
I was coming back up the stairs because he'd never gotten like this, ever. I mean, he's pushed me a few times, and I don't know if I should tell you everything.
Well, the more you tell me, it helps me understand what happened.
God, please help. I'm about to throw up. I just need to know how he is.
We'll find that out in a minute. So
asks you at the front end of this scene we just watched, is he alive? Is he okay? Right?
Yes.
She's checking to see if he's still alive. That's her question to you. Right?
Yes.
You tell her we'll learn out here in a minute, which obviously you knew he was deceased, but you're keeping that from her. You don't disagree with that.
Nope.
And then she says, I don't know if I should tell you everything. And before that, he's pushed me a few times. I don't know if I should tell you everything. And then she says, please, God, please know, I just need to know how he is. Bottom of page 9. Correct?
Yes.
Before she makes the statement, is he alive or dead? Please just let me know. Please let me know. You tell her you don't know. Then she says, I don't know if I should tell you everything, and asks again, is he alive? And you say again, we'll find out here in a minute. Right?
Agree.
Certainly, you suspected there was something you weren't being told.
Yes, as the interview grew on, there's more and more questions.
Right here, where she says, I mean, he's pushed me a few times. He's never gotten like this ever. I mean, he's pushed me a few times. Pause. I don't know if I should tell you everything. You suspect when she says that, there might be things she's not telling me about the history between these two. Correct?
Well, that is when I said, well, the more you tell me, it helps me understand what happened.
Sure. And the more you tell her helps her understand what's actually going on here, whether he's alive or dead.
Objection argumentative.
Fair enough. Withdrawn. It seems to me, and you disagree with me if I'm wrong, she seemed to want to know if he's alive or not before she's going to tell you about the things that have happened. Do you agree or disagree?
Disagree.
Tell me why you disagree.
Because I think she was cleaning up the scene. She knew that she had made a mistake, and she was trying to figure out. I think she probably knew he was dead because she did make a comment, there's no pulse. But she's just, at this point, trying to figure out the story she's going to stick with, because she started off strong with the stage scene. It was a shootout to, oh, he never shot at me, to where she even cleaned up the evidence and then through your own state, shot the gun. So she's trying to come up with a story. I think, personally, that at first she thought it'd be easy to conjure up a story. And then when she's sitting in a room with an investigator, it's not so easy to come up with the facts and the details, and that's why we're harping on this.
In other words, when she says, he's pushed me a few times, he's never gotten like this ever, I don't know if I should tell you everything, you did not think, hey, there's more to the violence between them in the past. You didn't think that.
Yes, I always think there's more, and I want them to tell me. Like, that's always the goal.
Right. That's the goal, right? You want to know.
Yes.
And she's hinting to you, I don't know if I should tell you everything. Is he alive? Is he alive? Is he alive? Right?
For the picture you're painting, I see where you're going, and I will agree with that, but there's two sides to it, I believe, so yes.
All right. Chris, go ahead and roll it.
Stairs.
It was like, I don't know if he shot the gun or if he slammed the door, but something like went flying. I don't know, something was really loud. And then he said he had my journal and my gun, and he locked the door when I got up there. And I told him, I said, I'm going to shoot the lock off if you don't open the door and give me my gun. Give me my cell phone. And I shot the lock. And he must have been standing right there.
This this is the first time where she's actually demonstrating for you how it was that she shot the lock physically. Did you see it?
Yes, and then with the statements made, yes.
Yeah.
Then where she finished with, I heard him.
When it comes into her mind and she's remembering exactly how this went down, you would agree with me, what she's doing is going like this. Did you see that?
Mhm.
You would agree with me, that's exactly how she's describing how the shot is made. Right?
In this context, yes.
One of your biggest arguments for how it is that she must have intended to kill him is because that shot's way too high if she's shooting at the lock.
At some point in the interview, she says she was standing close to the door, and that shot was too high, and she also says multiple times that she heard him.
And we'll get to every one of those.
Okay.
You're saying this shot's way too high if she's shooting at the lock. And she's demonstrating for you, literally, this is how I fired the pistol. Right?
I see your demonstration, yes.
Yeah. And if somebody is actually holding a pistol like this, are they going to be accurate with that pistol?
Depending on, that's. In a sake of argument, I could say they would hit their target, yes.
Okay. That's how you hit a target.
Well, when you're close distance point shooting and you're speculating that, I would say that yes, you could still hit a target without looking at the front sight.
Okay. Let's go 5640. Ms. Van Rossum. Stop calling me Chris.
He put his gun on my lip and said, I'll shoot your brain out and blow it up his end of throat. That's when I said, I got a gun too, David. But why did I shoot the lock? Why was I going to shoot the lock off?
So when he stuck his gun in your mouth, you don't
No,
understand?
he stuck it to my lip.
Oh.
No, he didn't put it in my mouth. No, he put it right on my right.
She says he put his gun on my lip. It's very specific. Put his gun on my lip and said, I'll shoot your brain out, what's left inside of your brain. You see that? This is page 11, I'm sorry. Page 11.
Yes, this time she does say that there, this
Right.
time.
It's very specific, on my lip, right?
And other times she says, I'll shove it down your throat. Like she bounces back and forth with the same promising statement.
I'm talking about where the gun is placed on her physical body by Mr. Barron.
According to her statement,
Yes, sir.
yes, that is what she said at this time.
Well, and we'll talk about whether she said something different, but he put this gun on my lip. Very specific, right?
Yes.
And then you say, so when he stuck his gun in your mouth on the stairs, and she corrects you immediately, doesn't she?
Yes.
She corrects you, no. He stuck it on my lip, not in my mouth. He put it right on my lip.
Mhm.
Right?
Yes, that's what.
It may sound like a small point, but she makes that point over and over and over again with you, that the Beretta was on her lip, not in her mouth. Doesn't she?
Yes, she said it multiple times.
What was in her mouth if it wasn't the Beretta? If you know.
I do not know.
5843, Mr. Van Rossum.
touch it. I know better. I wasn't trying to shoot him. I was just blowing him. I was trying to, and I told him, I said, if you're not over the door, I'm going to shoot the lock off, David. I don't know why he walked over there.
The statement she makes is, I don't know why he walked over there. Did you hear that?
Yes.
What's critically important, if we're trying to guess at her intent in shooting through a closed door, is does she know what's on the other side? Does she know where he is? You would agree?
I will also say another point. She says she thought he was on the bed. That is still the same direction of the bed.
Absolutely, I agree with you. She does at some point say she thinks he's over on the bed. I agree with you. Here, well, first, do you agree that determining where she knows where he is on an outside of a closed door where she can't see, you don't disagree she can't see on a closed door?
I do not disagree that.
We're talking about hearing. We're
Yes.
talking about hearing is her only sense to know where he might be.
Yes, and she stated multiple times she heard.
We're going to talk about those, okay? But the first thing she tells you is, I don't know why he walked over there, meaning to the place where he got shot. Right?
Yes.
Walked over there from some other place, right?
Mhm.
And the other place that she does mention, and we'll get to in a minute, is on the bed.
Yes.
Okay. You go ahead and, well, let's go to, 10204.
If you don't mind, what page?
It is on page 15.
Sorry, what? Okay. Would you like to take a break now?
Maybe we should, just for, yeah, at this point. Thank you, brother.
We're going to take an early lunch. Let's come back at 12:45. I appreciate all the jurors' attention. I understand we're now into week 2 of your time. I will say that this is a serious case. We have serious lawyers. We need your serious attention. And if you need to drink coffee or Monster or whatever you want to do, I would encourage you to do so. Back at 12:45 for continuation. Thank you. All right, y'all can be seated. Anything from the state?
No, Your Honor.
Anything from the defense?
No, sir.
On defense's objection as it relates to the expert in the medical records, I'm not quite sure, so I'm going to give you kind of a preliminary ruling, and y'all can work around it or let me know if you need clarification. The state's motion is granted to the extent the defendant must permit the state to inspect and copy medical records or reports that the defense expert actually relied upon in forming the opinions to be offered at trial. This is obviously consistent with reciprocal discovery, which requires disclosure of the basis for expert opinions, including summaries of underlying reports of examination or tests when the defense intends to introduce such evidence. We're not at that point, obviously, but it is arguably we're getting to that point, so this may be premature and it may be moot. To the extent records involve defendant's own medical information and privileges asserted, the court finds any privilege has been waived by the defense decision to place the defendant's physical or mental condition at issue through the expert's testimony. Again, I assume that's where you're going on that. However, if the records, this is important, however, if the records are in a third-party materials not in the defendant's possession or control, the state can proceed by subpoena and appropriate notice if appropriate. The court will allow a reasonable time frame if we need to. Not saying the parties have to cooperate, but certainly that would be appreciated to not delay the trial. But if we need to, under reasonable, we can.
Judge, I don't mean to interrupt, but while we've been in court, I had my investigator contact the jail, and he was able to get me all of the defendant's jail intake records.
Okay.
So I have about 800 pages worth of jail intake medical records for the defendant. So
Thank you for that update. All right, so assuming that that's everything, if specifically requested, subject to in-camera review, if y'all can't agree upon something, let me know.
Yes, Your Honor.
And I can do an in-camera review for sensitive portions and go from there. So it sounds like y'all are heading to the a meeting of the minds, which is fine with me. We're not quite there yet. If you need further court involvement, let me know.
Yes, Your Honor.
Thank you.
All right, anything else?
Not from the state judge.
No, sir.
See you in an hour and 5 minutes.
Your Honor.
All right, we're back. Anything from the state?
No, Your Honor.
Anything from the defense?
No, sir.
Let's bring them back. Thank you. You're correct. You want it back on your laptop?
Yes, sir.
All right, welcome back. Thank you so much. All right, thank you so much. Please be seated. We have everyone back. Thank you. Again, if anyone needs a break, let me know or let one of the bailiffs know. Any longer-term issues, let us know as well. All right, we're back to examination, cross-examination from the defense. If you would hit the red button on that microphone and turn it to green. Perfect. All yours.
And we're going to go to 106. 106.11, that's on page 17 of your transcript at the top. Okay? Go ahead.
Wealthy,
When did you find this out?
because his son told me that he was sending her money 2 years ago.
Okay.
Yeah, and that he found out, and he said, this has got to stop. His son did. And, because this is, I told, one night I called his son, because his dad was drunk, drinking, and I took his car keys from him, and he got mad and pushed me. And I called, but I was scared. I locked myself in the closet. And he threw, and I took the car keys, so he was like looking everywhere for car keys, and so he like threw all my stuff everywhere in the closet, and I was just in the corner.
When was this?
Okay. This part of the interview, she's talking about the telephone call from December the 28th, 2024, that she placed to James David Barron's son, Evan, right?
I would agree. It doesn't say his name, but I would agree through the context.
And her statement is, I called his son because his dad was drunk or drinking. I took his car keys from him, and he got mad and pushed me. Right?
That's what said, yes.
Then she says, I was scared. I locked myself in the closet. Correct?
Yes, that's what I'm reading.
I took the car keys, so he was looking everywhere for the car keys. And he threw all my stuff everywhere in the closet, and I was just in the corner. Right?
Yes.
This version about what happened on 12/28/24 involves her taking the keys to the Kia, to Mr. Barron's Kia. Right?
Yes, I mean, it doesn't say
And you
key,
know
but-
from your other investigation in this case, you spoke to Mr. Barron, you spoke to Evan Barron,
Yes.
right? And you knew that there was a row or an argument or a problem involving a closet, right? Involving Miss Mericle being locked in the closet, right? Yep, sorry, you have to say yes or no.
I don't remember locked in, but I do know the argument on the 28th, yes.
Okay, but she's in the closet,
According to this, yes.
and according to your other information that you have,
Yes.
right?
Are you talking about the interview with Evan?
Yes, sir.
Okay. Whatever his testimony was, yes, I don't
Yeah,
recall.
and you were in here.
Yeah.
Yeah. She was locked in the closet.
I believe so.
Okay.
I don't, I mean,
And Mr. Barron, James David Barron, is outside the closet, and what he wants is his keys to his Kia. Right?
yes, I believe so.
But where is this spare set of keys that's just freely available to find in the home on 12/28/24? Do you know?
According to the son, it was in the pantry area by the kitchen.
And we'll talk about that in a minute, but I mean on 12/28/24. Where was this spare set, if you know?
I do not know. I mean,
Okay. Chris, if you can go to 1:16:53. 1 hour, 16 minutes, 53 seconds.
but,
I know not to shoot a gun at a damn door. I know that. I didn't have to do that. I asked him to give me my phone. I asked him to give me my phone. I told him, I said, I'm going to shoot the lock off if you don't give me my phone, David. And that, how am I ever going to live with myself?
So you said you had to go down to get your gun and go back up.
No, I didn't. No, I never went up until I had my gun.
Where did you get it from?
My gun
Yeah, where was it at?
in the master closet.
In the master closet. Is it in a safe or anything there? Just, okay.
I just bring it with me when I travel.
Okay.
Can you tell me anything about him, please?
I'll go call it here in just a second.
When the police came to my house on St. Simon's,
When was that?
She asks again about his medical status, right?
yes,
And you say, I'll call here in a second, right? But obviously that's not something you're going to do because you already know, right?
yes,
And then there's a pause, and then she says, and the police came to my house in St. Simon's, right?
yes.
Okay, go ahead.
January?
he took me outside.
What is your address in there?
Well, my address is, I use my office address for everything, but
Okay.
my house address is 10 Marina Drive.
And that's where they came to, was 10,
They came to the Seagate Inn.
the Seagate Inn.
It's a hotel. And I was staying there. And they came there. Somebody called the police because they said they could hear him yelling, and the police came, and then he took me outside and asked me what happened. And he said, "Did he hit you?" He said, he said, "What are those marks on your face?" And he told me that I should call the police and press charges. And I said no, and then he left. Then the police left, and then David left.
So they had him leave. Did the police have him leave, or did he leave on his own?
No, I told the police everything was okay. We told them it was okay, and they came in and talked to us, and then he said he was going to leave, and the police said okay. And the police left, and then David left. And then I called a friend of mine, and then I went to my condo.
And that was January of this year, 2025?
She's relating to you the St. Simon's incident
Yes,
that we know is from January I think the 28th. Does that sound right?
approximate.
And her version here to you is the police come there, somebody else called because they could hear yelling. She never mentions anything at all about the softball size injury to her head, right?
The one that she got from falling on the ground from the door,
The one that she sustained from David Barron on this incident.
I think that was inaccurate from the testimony, but I do agree that she had one from that testimony, but that's not what we received, so yes.
I just want to be super clear. Does she tell you guys, I got a softball size injury on my head from this St. Simon's incident?
We'll read it one more time. Just make sure I'm not missing anything in these 3 paragraphs.
Okay.
So what I read here is those marks on the face, which I believe the officer testified he was able to identify by her rubbing her cheeks. But I don't see anything about a contusion here.
The answer to my question would be no.
Yes, no, correct.
If she's trying to do what you've suggested that she was doing here, which is to stage a scene, make it look like she's defending herself or something like that, why not tell you about this documented injury that she sustained at his hands?
Why not? I mean, I can't answer that question, honestly.
You don't have a theory?
You want a theory?
Yes, sir.
Okay, I thought we were talking factually. Again, I think at this point, the stress is through the roof. She had just shot somebody. She knows what happened. I can't even imagine to say what was going on in her head, what she's trying to come up with and not come up with. And I don't know why she didn't tell me about this in this part right here. I can't comment on that.
Well, but you've suggested that what she's doing is trying to come up with a version to mislead you and make him be the one who's guilty here.
I think she was coming up with a version to make me understand the scene. That's what I was testifying to. Why nothing's adding up. She started off with, yes, you're right. He was violent. He did all this with a gun, but then we get here and she never wanted to tell me about the facts of the scene. And that had changed rapidly through the interview.
She's started off with these deputies before she thinks he might be alive. She's telling them all sorts of things. I was so scared. Prior violence, she actually nods. I thought he was gonna kill me. Don't go to sleep. I was gonna leave, but I was scared. If I moved on, he would kill me. He would shove that gun down my throat. I wanted to sleep upstairs where the door locked.
Judge, I'm gonna object that defense counsel's not actually asking a question, he's just
The
reading his
question's
own
coming.
notes.
Question's coming.
What's your question?
Question is, she's told first responders that, those statements, yes?
Yes.
Those are statements that someone's afraid. Someone could be afraid because they're being assaulted. You wouldn't disagree with that?
No.
And then she gets in the interview with you. She thinks you would agree that he's still alive. At least that's a possibility.
That's a possibility.
And she's got the opportunity to tell you, hey, I've gotten this giant injury from this man, and she completely leaves it out. Right?
You keep saying she got it from the testimony we heard, that through the door fell back and hit her head. He did not intentionally give her that from the testimony we heard.
Even under the version the police got, he blasts through the door, knocks her over, and she gets a head injury.
Yes, as he was locked out to get her stuff, yes.
And that's her fault.
Hey, I'm not drawing blame here, I'm just getting the facts straight, yes.
Okay. Well, all right. Well, why all this to the first responders, and then as soon as she thinks he's alive, why doesn't she tell you about it?
That's what I'd like to know.
$126,000. Did we just do that? Did we just do 126? Okay, 126,000.
Police come to St. Simon's Island because someone called about.
In January is when the police called. When someone called the police, they came to my Seagate place and said someone heard him screaming. And then they left, and then David left. No, yes, wait a minute. No, yes, that's what happened, yes. That's what happened. Wait a minute, hold on. That's the night my friend. Yeah. I think that was, the police came was in December, because they came, and then my friend, a couple of they came over and followed me to my other condo. I unlocked the door because David could get into the Seagate when there was a code.
Okay. And then.
Another opportunity to talk about the St. Simon's incident at Seagate and to mention the injury, but it's not mentioned here. You would agree?
Yes, she did not mention it here.
128 and 47, 128, 47.
What page?
It's page 30, top of the page. That's good. 153.40.
Oh, God.
$159.27. $159.29, Judge. Page 31.
But when he threatened me, he didn't put it, he just touched it to my lips. He didn't put it in my mouth. And then he went up the stairs. And I said, I have a gun too. Because he said, don't go to sleep tonight.
Yeah.
And then I went and got my gun. Okay. He was up the stairs. Then I noticed that he had my phone. So I went up the stairs and I said, when I went up to the stairs, I got right to the first floor, and then I heard, and it sounded loud. And I don't know if it was a shot or he slammed the door. But when I got up there, the door was locked. And he was in, and I said, do you have my phone? He said, yes. And I said, open the door now. And I was banging on the door. And he did open it. And I said, I'm going to shoot the lock if you don't open it. And that's when I put my gun right in the corner of the door, like where the lock is right there. I think I put it a little bit. And I either put it up and shot, or I know I shot one down because I saw it and it scared me when I did it.
At this point in the interview, she talks to you specifically in that, probably about fourth paragraph down, about an interaction, what seems like at the door, right? She's saying, do you have my phone? Middle of that larger paragraph. And he said yes.
That is correct. She heard him say yes.
And I said, you open the door now, right?
That is her statement.
And I was banging on the door.
Yes, correct.
And he didn't open it. Correct?
We agree on that.
And I said, I'm going to shoot the lock if you don't open it.
Yes.
Will you agree with me that in all of these hours of questions that you had for her, you never asked her a single question about where David Barron was in the room when he responded to her and said, yes, I have your phone?
Well, it's pretty obvious.
How is that obvious?
Well, she heard him. She struck him, so we know exactly where in the room he was at the time.
Will you agree with me? You asked her zero questions about where he was in the room when he responded to her. Yes.
I'll agree with that because I knew where he was.
Because you knew where he was.
And she did too when he said yes.
In other words, when someone says something on the other side of a closed door, the person on the outside of the closed door knows exactly where they are in the room.
If you say something, yes, you can get a direction from sound where people are.
Wouldn't it be helpful to say, Ms. Mericle, when he said yes, where did you hear him in the room?
Hindsight is 20/20, and I do agree.
We know, and she says this at some point, I thought he was on the bed.
That is correct.
Why does she not think he's on the bed when he says yes?
Well, in all fairness, where he was standing and where the bed is a straight line. like where he would be laying in bed versus where he was standing, is still very correlationally appropriate.
Meaning, even if he's in the bed, the shot that she took would have got him on the bed.
No, I'm not saying that. I'm saying that it's still the same direction.
Okay, well, let's just see, okay?
Is there a crime scene photo from the door that is a little more representational?
Yeah. Why don't you come and help me find it amongst these hundreds of pages, if you can. No, they're clearly not in disarray.
Right here, right here. This is, there's the thing, right there, first one. The bed is still in the same direction. That's where he was with the door.
Let's come on down. We're looking at State's Exhibit 45, okay? Can I have the witness step down, Judge? To demonstrate on State's Exhibit 45?
If you don't mind, use a Elmo at least preliminarily. I'm not telling you how to try the case, but I can't see what y'all are looking at.
Can I do it if we switch off the camera? Will it?
Yeah.
Can we lose it?
Well, no guarantees on that, but.
Okay, fair enough. Okay.
All right. And again, you might want to adjust the neck a little bit of it. There you go.
Is that better? There's a little bit of glare there, obviously, but I'm going to do this.
All right. And then if you don't mind, use whatever screen y'all want.
Well, first of all, the shot comes through right through here, so we think he's here, right? When the shot happens.
Yes.
Yeah. And she's right outside there.
Mm-hmm.
If she thinks he's on the bed, that's not in the same direction.
It is, it's, excuse me, not being argumentative, I'm just, the bed is over here. If you look at the layout, yes, that's, when I was at the crime scene, that's one thing I was looking at. It still goes back towards the bed.
Okay. Where did we leave off? 2 and 53? Judge, can we switch back? I'm sorry. We had 2 and 53. All right, let's go to 2:18:57. And that would be page 40 for you.
I think I just found it, yes.
Come back some as opposed to. That's 2:8:52, that's fine. 2:18:52, Judge.
I don't know why I got it. I mean, and then when I went up there and the door was locked, I was like, David, open the door. Give me my phone back. I banged on the door, banged on it, and he went open. He said, I have your book too, or journal, or whatever. And I said, David, give me my stuff. I said, okay, I thought he was gonna open the door, but there was no screaming, nothing. And I said, David, I'm gonna blow the bolt off or the gun or shoot the lock off. And then I shot. I just think I shot it one time.
Here she's describing banging on the door, banging on the door, banging on the door, and he wouldn't open it, right?
That is correct.
I have your book or journal too or whatever. David, give me my stuff. I thought he was going to open the door, she said, right?
Mm-hmm.
Then she says, there was no screaming, nothing. And I said, David, I'm going to blow the bolt or shoot the lock off, and then I just shot, right?
That is correct.
This still doesn't help us to understand where he was in the room from her perspective. You would agree?
With the earlier statement of her saying yes, and then now, when you add this statement to it, we also have him saying, now we've added to this that I have your, let me find the exact quote.
Your phone in your journal.
Yes, now you have your phone in your journal, which also adds to the yes, which gives more dialogue and more voice behind the door for locational purposes, I believe.
You don't think this is just a further explanation of the one statement that he made to her, I've got your phone or journal, or yes?
No, because I think when she was threatening to blow the lock off the door is when he moved to the side of the door. You know, he knew if she shut that door, he did not want to be in front of it. So it was just a voice.
Hang on. If he thinks that she's going to shoot the lock, this is one.
Hypothetically, that's what really happened when we're in there.
If he thinks she's going to shoot that door, if he thinks she's going to shoot the lock off, why would he go right in line to the lock?
Speculation.
He didn't, he stepped
Judge,
aside.
objection calls for speculation.
I'm not commenting on the evidence. Jury will make the determination. I will allow the questioning to continue overruled.
He didn't stand in line with it. He stepped aside from what he thought in line was.
This is the wall outside of the room right here, okay?
Mhm.
And the door is right here in front of me, right? And she's saying, I'm going to shoot the lock off. And he goes and stands exactly right where the shot comes through the lock.
Unfortunate. And that's why I think she heard his voice, because most people would intentionally think you were going to shoot straight in, not an angle through another wall for somebody to take a defensive position.
If she's announcing, I'm about to shoot, wouldn't you think you go further back into the room or the closet? There's a
More off
closet
to the
there,
side.
right? There's a closet there.
Coming around, yes.
Yeah.
But I can't speak to that. I just know that he was standing off to the side. He was not standing directly in front of the door.
Page 44, if you wouldn't mind. $26.55, Chris. And you can go a little bit beyond 226.55 if you get close. That's probably fine.
No shell casings.
So where were the other holes?
In the glass?
In the bedroom?
No. In the window.
Well, I only shot to the door.
You only shot to the door,
With my gun.
and he never shot, you just heard him slam the door.
You know, my ear.
Yeah.
But it's,
But you didn't hear a couple of gunshots, you just heard one loud bang.
I heard a loud thing.
We know for a fact that one shot went through the door, striking Mr. Barron. True?
Yes.
We have ideas about how many shots came out of the bedroom afterward.
Yes.
Cameron Durham says 3 is his guess,
Yes.
right? Could be 2. But 3, 2, 3, 2, right? One of those.
Yes.
And again, your words. If she's trying to stage the scene and tell you a story, why would she say that he only fired one shot?
Because at that time she knew that she could no longer hold the story. She was in an interview room stress. She couldn't make the fine details work.
Well, she certainly would know how many times she fired his gun if she's the only one who fired it, right?
At the same time, she's also telling me how she didn't flush shell casings.
We'll talk about that in a second. But
So-
she knows how many shots are fired.
if the interview at this point, I believe, was truthful, we could have this conversation, but I can tell you what she said.
My question is, why doesn't she tell you there's more than one shot that he fired at me?
Judge, there's so many speculative questions here that this witness cannot testify as to why the defendant did or didn't say something, what she was thinking, why she was thinking it. These are all speculative questions.
Y'all come on up.
Two 3804, Ms. Reynolds.
He's got a really big heart.
Sounds like he's a great guy. Sounds like he's a great guy from what you've been telling us.
But why did I do that? God, how am I going to tell my children? How am I going to tell his children? I shot him. God, please let him. God, please take care of him. Why did I do that? I was going to leave, but I was scared to leave.
Here, you've left the interview room, and only Detective Cuneo is in there with Miss Mericle.
That is correct.
And what we get is another statement about being scared to leave, correct?
Yes, the context, though, follows up with, because of last time, there's no way I was intoxicated.
Going back to the ability to leave while being under the influence or while consuming alcohol.
Yes.
23928. Oh, boy.
50.
Hang on one second. Oh, my gosh. $239.28.
On the phone at the door and you were...
No, we didn't go back and forth.
Okay.
No, we didn't. I said, "Do you have my phone in there?" or whatever. And he said, "Yeah." I said, "Give me my phone, give me my phone, give me my phone." That's it. I said, "I'm going to shoot the lock off if you don't give me my phone now." Nothing. And so I shot him.
Investigator Cuneo says to Ms. Mericle, you said y'all were going back and forth about the phone at the door. You see that?
Yes.
And Ms. Mericle responds, no, we didn't go back and forth. Right?
Correct.
And then she says, nope, we didn't. This is Ms. Mericle. Nope, we didn't. I said, do you have my phone in there or whatever? And he said, yeah.
That is correct.
Right.
To see where she she was able to hear him say yes.
We've been over that, that's for sure, right?
Yes.
She heard him say yes, right?
Yes.
The question is, where is he in the room when he says yes? Right? Right?
That is your question, yes.
And then she says, I'm going to shoot the lock off if you don't give me my phone now. Nothing. And I shot it. Correct?
Correct.
241-12, Mr. Van Rossum?
I mean, 3 hours ago, we were together. I'm such, I don't even know. I don't even know what to say. I know better. I'm sick. So hot. Why did I take my gun up there? I really thought he was going to be on the staircase waiting for me with his gun. What, we're going to shoot each other? I mean, God, I wish I could go back. I would have never. Why? I mean, I don't know why I didn't wasn't planning on doing anything. And he was right there with it. I'm just like, I don't think, if you ask me if I'd shoot the door, I'd tell you no. If you ask me, I think he'd shoot me and say no. But when he put the gun like that and said that to me, he's never done that. And when he hit me in the head, he's never done that.
Here, Ms. Mericle is stating that he has never pointed a gun at her. I think she says like that, right?
That is correct. That's what I'm reading.
And when he hit me in the head, he's never done that.
That is what it says.
246:51, and be careful about your start time here.
What page, sir?
Page 52. 46:51. That's better than 246, than being earlier, yeah.
Then he wouldn't let me get out. And I never thought he would do that.
Can you roll it back and go to 246:51?
And you say that's, what
It's on
page?
page 52.
Oh, 52.
Middle of the page.
Okay.
May I approach witness? I'm just going to indicate something on the transcript.
I was on 51. Yes, sir.
We're not talking about that, so
That's fine.
cross that out.
Okay.
Yeah, it starts with there.
Okay.
Okay.
Yes.
246:51.
Good. Then he wouldn't let me get out. And I never thought he would do that. I can't believe I was shot. He said, I thought he was laying in bed.
You hear that one? I thought he was laying in bed.
Yes.
Two 4900.
I should just got in my car. I told him, I said, I'm just gonna go. I'll just go and get a hotel room, okay? And he said, you better not go. You won't be able to get your car started. I said, well, can I take your car? He said, no. I forgot about that part. And there's no lock on my bedroom door.
I should have just got in my car. I told him, I said, I'm just going to go. I'll just go and get a hotel room, okay?
Yes, that is what's said there.
And then Ms. Mericle says, and he said, you better not go. You won't be able to get your car started. Correct?
That is correct.
I said, well, can I take your car? And he said, no.
That is correct.
And she says, I forgot about that part. And then the next line is, and there's no lock on my bedroom door. Correct?
That is what's said here. I mean, there's,
And this is sort of similar to what she was saying earlier about there being no lock on the door downstairs, but the lock's upstairs.
there's other bedrooms in the house, yes, that do have locks,
Right. One of them is upstairs
and one of them's downstairs. Yes.
in the basement,
Yes.
which we haven't seen
Okay.
any,
Yes.
I don't think pictures or photos or videos yet of that
Okay.
further downstairs. Would you agree
Yes.
with that?
Yes.
Looking at (3 hours, 3 minutes, 13. So 3:03:13.
6-0.
Page 60, exactly.
Not doing anything with the door open, right?
Oh, yeah. When I
So-
pushed the door open, he was there.
And all you heard was loud bang, not multiple loud bangs going on.
The only thing that could happen is he had his gun.
Mm-hmm.
He had his gun with him, so if he shot his gun, he shot that. Before, when I was walking up the step, I heard a louding. I think it was the door, but he's the only person that would have his gun.
But it was only one, wasn't several
Several what?
loud bangs? Just one?
I just heard one.
Okay. So,
Another opportunity to say multiple shots, and she goes with one.
Correct.
And also, it could have been the door.
Yes, we were leaning towards the door, I think, for the most part. She was.
3:04:04.
I guess so he'd see it. So I was thinking when I came back up that he was going to be there. I don't even know what I was thinking. I was just thinking when I came back up those stairs. That he was going to be there, but I didn't bring it like to hurt somebody. I didn't. And then when the door was locked, and he didn't say, I thought he was laying in bed.
Another statement about thinking he was in the bed. correct?
That's what I heard. I can't find the spot in the transcript.
I'm sorry, I should have directed you to it. It's my fault. Page 61,
Okay,
it's the second large paragraph.
yes, okay. But that is what I heard.
Miss Ellie? Okay. Let me show you what I'm marking as 9, 10, 11, and 12. First witness? Yes. Showing you defendants 9, 10, 11, and 12. Take a look at those. See if you recognize those as your crime scene photos.
Yes, this is going to be from the living room looking at the kitchen.
That's defendants
Table
9.
with the power tools.
That's number 10
Yes, and yes, I recognize them, but yes.
and 11. You recognize 11 and 12?
Yes,
They fairly and accurately represent the crime scene.
yes.
Moving to tender 9, 10, 11, and 12.
No objection, Your Honor.
Admitted.
May I have the Elmo again, Judge? Nine is orient, folks. Right on top of this chair over here on the left-hand side, you see where I'm indicating here? There was a bullet fragment on top of the back of that chair that was found, right?
I believe so.
This is the dining room table here that we see. There's the kitchen island.
Yes,
Behind that is the range and the backsplash and stuff like that.
yes.
Looking at defendants 11, this is sort of a closer up view of that area, of the island area,
Yes.
right? And 10 is sort of the other side of the island. I'll show it to you. Right? And to be clear, a spare set of keys is not visible in defendants 10, 11, or 12. You would agree?
I would agree, but I do think their testimony, and I did not see them, so this is not mine, but would be the pantry.
That's right. That's why we're going to defendants 12. You ready?
Yes.
Defendants 12 is that pantry area, right?
Yes, if you go through that little arch, it hooks back to the right, and there's a little table there. Yes, the door's kind of blocking one of the tables right now, and that's the door to the garage.
You would agree with me, we've got no pictures of that pantry area taken by crime scene, at least, that you're aware of. And
If
you don't
there's
have-
not, yeah.
Yes, but- I didn't-
Unfortunate if there is not. It's very unfortunate.
Do we know whether any of the deputies who had body camera running and who came into this house might have walked right into that pantry area and been able to see what was out on the counter, whether there was a spare set of keys or anything like that?
I do not know, but like I said, I think this is more something for the person that actually found the keys.
Sure, and my question is just whether the keys are open and obvious, laying out where anybody would see them immediately, right?
I understand your question, yes.
Have you reviewed Officer Ingalls?
I know him, Sergeant Ingalls, and no, I have not reviewed his body camera.
Okay. Deputy Feraldo, Michael Feraldo?
Lieutenant Feraldo,
Sorry, Lieutenant.
and I have not looked at his body camera either.
Okay. Okay. But to be clear, those body cameras are in your stuff, in your case.
They should be, yes. I usually go for the deputies. We can ask them. I mean, they're uploaded to the same system, evidence.com, yes.
Yep, okay. All right. I want to talk to you now about the texts on the phones, meaning the texts on Ms. Mericle's phone that you've reviewed and testified about here today. Okay?
Yes, we're doing this?
Yeah, I mean, you know, there's, and just to remind everybody, what you did in part was you got Mr. Barron's phone and also Ms. Mericle's phone, and you gave it to the, I think it was London, Investigator London?
So that process, Sergeant Durham collecting his evidence, then during the process and putting it in proper evidence, I prepare a search warrant, and I give him a search warrant, and he retrieves it from proper evidence. So just to be clear.
May I approach? Just get. This is I'm showing you States 186 that was previously admitted,
Yes.
and this would be Mr. Barron's
Yes, it's clear, so,
cell phone,
yes.
and they've called it a clear case. I want to open this up. Do you have I'll rip it if you don't have
I do not have a knife on me, but you may want
All right,
this.
let's take a break.
Sorry.
Back in 15 minutes.
Why don't you grab that stuff?
All right, y'all can have a seat. Let's be disciplined on how we're dealing with that, please. I'm not trying to imply anything, but it's an evidence bag, so if standard protocols, you use gloves, you use gloves. I don't want there any allegations of cross-contamination in the courtroom or anything like that. So, I mean, whatever SOP is on that, I need y'all to follow it. So let's take a moment on how we want to handle that.
Okay. I'll get with the state judge and see what they want.
And then lawyers approach, if you don't mind.
as far as it's.
My absolute preference would be turn 45 degrees.
If I ever would save it, so that if about the court, so I can see.
This is 45.
And even like this. Some more. Turn towards you. Like that. 5.
About 20. All right. What about this?
Now I'm not sure they can see.
No,
Yeah.
I'd bump it back. Just a hair.
As long as you're happy, I'm happy.
You know what?
I'm not a scientist. You got about 10 degrees of play in there. All right. The court doesn't have to anything else to talk about at this point. Anything else from the state?
No, Your Honor.
Anything from the defense?
No, sir, when are we coming back? I'm sorry, I didn't hear the time.
I think it's 2:05 is the time. I will ask the state lead investigator in the defense to coordinate how we're going to start opening things. My preference is I not be the one that do that, but FYI.
Knife or something?
We could get you some scissors from my office if need be.
We normally just have Ed use his pocket knife.
You do?
We don't have one in here.
Okay, y'all coordinate, please.
Is
All right, welcome back. Thank you. All right, welcome back. Thank you. All right, thank you so much. Please be seated. Thank you. Make that button green. Yep, we're ready.
May I approach the witness, Judge?
Free reign.
Are you gonna hand me this?
Well, I'm going to go ahead and just take out State's Exhibit 186, which is the iPhone that belongs to Mr. Barron, okay? It's got a clear case on it. That's a word, whatever word we want to call for that, light brown, clear, something like that. Fair?
Yes.
And the reason I want to take this case off is because I want to talk about the actual color of the phone, okay?
Okay.
I'm just going to pop it off. If I can make it do it.
You want a glove on the other hand? That's got blood all over it.
This is never going to work. Do you know what the actual color of this phone is?
I do not. I think I was told it was black at one time. I think it looks,
I think it's gray.
it's my first time actually handling it. I'll look
Okay.
at it.
If you can if you can pull off getting the case off, then great. If you can't,
Yeah, I don't.
did you know that Miss Mericle's phone, which is 182, is a iPhone with a blue case on it?
Yes.
And we can pop off her case and see that it's a blue phone. Would you agree with that?
Yes.
Blue. And maybe you take my word for it that Mr. Barron's phone is gray.
Yes, it appeared that way through the case.
Done with this? May I approach the witness again? Showing you what's marked as defendants' exhibits 13, 14, and 15. Let's take a look at those.
Yes.
You don't need gloves for that.
Well, you're just handle a bloody phone.
Okay.
Yes. Do you want me to hang on to these for a minute?
Yeah, just take a look at those and see if you recognize those.
I recognize these two. I do not recognize this one.
Okay, tell me which two you do recognize.
The text conversation between Ms. Mericle and David Barron, and the text conversation between Ms. Mericle and a gentleman named Charlie English.
Got it. And that's Exhibit 14 is the text conversation between Ms. Mericle and Charlie English.
Yes.
Defendant's Exhibit 15 is a text conversation between Ms. Mericle and Mr. Barron, right?
Yes.
And that one starts on March the 3rd of 2025 and runs all the way up to March the 7th at 11 p.m.
That is correct.
Move to tender defendant's Exhibit 15, that's the text between 3/3/25 and 3/7/25.
No objection, Your Honor.
14, you recognized as the text between Mr. Charlie English, starting March 5th, 2025,
Yes.
and ending March the 8th of 2025.
Yes.
Move to tender defendant's Exhibit 14.
No objection.
Admitted.
Defendant's Exhibit 13. You don't recognize these?
I don't. I do not recognize the phone number off the top of my head.
Okay. Well, let's see if we can figure it out. Nine 230-4039. Recognize that number?
Was that the 4309?
Should be Mr. Barron's phone as well.
Oh, okay. Yeah, no, 4309 was Susan's.
Don't recognize that number?
Not off the top of my head. She had it, Mr. Barron, I do know that the 4309, because that is the phone number she gave me. But hold on, let me look at some notes. I did have Mr. Barron's phone number. But no, I don't, I mean,
Okay.
if you tell me it's it, I'll be glad to read it.
We'll leave 13 alone since you don't recognize it. One of the questions, obviously, that you had was motive. True?
Always, yes.
Always. What motive was a question that you had and that you wanted to investigate?
Well, the facts and circumstances, up and foremost, facts and circumstances, and motive is always good.
And am I correct that your investigation, you believe the motive was that Ms. Mericle was angry about the relationship with Lilia Bocan, right?
We have historical amount of text messages to show that, yes.
We have loads of messages about her being upset about that.
Yes,
Other people have heard her talking about it as well, right?
yes.
That goes back to, my gosh, December the 28th of 2024, we think is when she found out?
That is the first documented incident we have, I believe. But did she say November, December at one point, maybe? I'd have to look at the messages to confirm. But yes, I agree with you.
The gist is, we've got something that happened literally months before the shooting.
Yes,
Am I correct if I state that you don't have any information at all about a new motive, a new thing that happened on March the 7th related to Lilia Bocan?
Not in relation to Lilia, if you're narrowing it.
Right.
I don't,
And we're going to talk about what might be new, okay? What might be new on March 7th?
are you talking about the ongoing graphic nature with Mr. English?
Yes, sir. So I want to talk to you about Defendant's Exhibit 14, okay? Wait for the elbow check.
I can't say anything about it.
There were messages between Miss Mericle and a person named Charlie English on Miss Miracle's phone.
That is correct.
Those are on Defendant's Exhibit 14 in part, right?
Yes.
You would agree with me that all of those messages, except for one or two, had been deleted off of the phone of Miss Mericle, correct?
Yes.
I'm going to show you Defendant's 14. This is from March 5th, from Mr. English to Miss Mericle. And he states, "It was nice, I'd love to do it again, and I would also love to see you." Correct?
That is correct.
And Miss Mericle responds, "I'm seeing my boyfriend this weekend, so we can discuss where we are. So of course, we need to wait, because we would be dangerous alone." Correct?
Correct.
March the 6th at 7:30 p.m., Mr. English says, "Hey, it's going great. I'm about to finish up and then go to dinner with some friends here. Did you get to the lake safe?" That would be the evening of March the 6th, 2025, correct?
That is correct.
And you know from your investigation that Miss Mericle drove from St. Simon's Island, arriving in the evening of March the 6th of 2025. Does that sound right? That'll be Thursday.
Yes, that was just, yes. I knew she was Thursday, so yes.
Thursday. And then Miss Mericle responds, "Sounds fun. I'm still in the car. I have 2 hours." And this is at 7:55 p.m. on March the 6th, right?
Yes, it was.
Is that correct?
Yes, yes, there's also a red when it says 8:03, but yes, I agree with the time frame. Yes.
Then Mr. English responds, "Ugh, you and always come to my house for a sleepover, March 6th, 8:04 p.m. Right?
It's no text, yes.
Miss Mericle responds, "I'm sure we would have fun. This is March 6th at 8:09 p.m.
Yes.
And what we're noticing, we already talked about this before, but I want to make sure that everybody sees it. All of these messages that are coming and being shared all have user deleted, right? And the deletion time and date on it. You see that?
Mhm.
They're coming in and being deleted by the user, which would mean Miss Mericle. Right? As far as you know.
Correct.
Miss Mericle responds, 8:10 p.m. My ex and I are going going to meet tomorrow to discuss us, so it was probably not a good idea. Correct?
Correct.
Also deleted, not present, deleted text, correct? And I'll shift back to it if you need to see it again.
Oh, no, you're good. Yes, I'm agreeing. I'm just, yes.
March 6th, 8:14 PM, Mr. English to Ms. Mericle, I respect whatever decision you make. 8:14 PM, March 6th, also deleted by Ms. Mericle.
Correct.
March 6th, 8:15, Ms. Mericle reacts to, I respect whatever decision you make, which was what his last text was, right?
Yes.
And it was also deleted.
Yes.
Then we have a new message, 16 or 18? 8:16 PM
Oh.
by Ms. Mericle to Mr. English. I appreciate you saying that. I know you have women fall all over you. And then the response by Mr. English at 8:28 PM on March the 6th, but I've always been intrigued and wanted you, correct?
Correct.
Ms. Miracle's response, March 6th, 9:08 PM. I am very strong-headed and sassy. Also deleted by Ms. Mericle, correct?
Correct.
He says, Mr. English responds, love and loved on March 6th at 9:08 PM. Correct?
Correct.
Also deleted by Ms. Mericle. 9:11 PM, Ms. Mericle says, ha-ha, also deleted by Ms. Mericle. This is still on March 6th.
Yes.
We're getting to the evening hours, really. 9:11 PM, March the 6th, which is the Thursday.
Yes.
Mr. English to Ms. Mericle, 9:45 PM, you don't scare me. And Ms. Mericle has also deleted this message as well.
That is correct.
Another message from Mr. English, 9:50 PM, heading home from Monroe back to Athens, also deleted by Ms. Mericle, right?
Correct.
I'm home, what are you wearing? Sent by Mr. English, 10:22 PM, deleted by Ms. Mericle, right?
Correct.
And then Ms. Mericle, March 6th, 10:39 PM, I do not want you to be afraid of me. Also deleted by Ms. Mericle, March 6th.
Correct.
Ms. Mericle, get all this screen here. Close to bed. I stopped and had dinner and I'm headed to the lake house to meet my boyfriend. I have on a pair of running shorts and a jacket. This is 10:39 PM March 6th, correct?
Correct.
Also deleted by Ms. Mericle, correct?
Yes, correct.
And then we have a message, March 6th at 10:40 PM, meeting your sassiness and being strong-headed doesn't scare me. Also deleted by Ms. Mericle.
Yes.
March 7th, 9:25 PM. We've jumped forward a little bit, okay? We're on March the 7th. This is the day and the evening, I guess the evening hours before the shooting.
Yes.
Looking at this March 7th message, Ms. Mericle says, he went to the store for a minute, correct?
Correct.
Deleted by Ms. Mericle, 9:25 PM, correct?
Correct.
Mr. English writes back, I will leave you alone. This is March 7th at 9:25 PM, correct?
Correct.
Also deleted by Ms. Mericle, correct?
Yes.
Then, 9:25 PM, March the 7th, Ms. Mericle writes to Mr. English, he wants us to get back together, correct?
Correct.
Deleted by Ms. Mericle, correct?
Correct.
Right at 9:25 PM. After he wants us to get back together at 9:25 PM, March 7th. The response by Mr. English at 9:25 PM is, "I'm sure," correct?
Correct.
Also deleted by Ms. Mericle at that same time, correct?
Yes.
Then Ms. Mericle responds, "Why?" Answering this question, "I'm sure he does want us to get back together." She says, "Why?" Question mark.
Yes, on March 7th at 9:28, yes.
And deletes the message.
Yes.
And then Mr. English says, "I'm sure he wants to keep you. You're an amazing woman." That's 9:29 PM.
Correct.
Also deleted by Ms. Mericle.
Correct.
And then March 7th at 9:31 PM. "Not that amazing. I'm tough to deal with sometimes," by Ms. Mericle. Correct?
Correct. And
Also deleted by Ms. Mericle.
yes.
And then Mr. English says, as a response, quote, "As we all are," at 9:32 PM.
Also deleted. Yes.
Deleted. 9:40 PM, Mr. English sends this message, "Sleep good, baby, I'm exhausted." And then Ms. Mericle has that deleted as well.
Correct.
She replies at 9:44 PM, "You too, sleep well," and then deletes the message.
Correct.
Now, at 9:44 PM, Mr. English reacts to the "you too, sleep well," meaning that he has, given a thumbs up or a like or a heart or something. He's reacted to that text, right?
That is correct.
In other words, he didn't write another text back. He just reacted to it with some sort of approval, right?
Correct.
And this is at 9:44 PM. This message is not deleted, correct?
No, status is red.
It shows it's been read. It shows that it's been read, and that just means that the person that has the phone has presumably looked at this message, this reaction. Someone has looked at it, right?
Correct.
March 7th, 9:46 PM, Ms. Mericle sends this message. "What would you do to me if I was next to you?" to Mr. English, correct?
Correct.
This message is also not deleted, correct?
Correct. Doesn't it? Yes.
Now, the next message from Mr. English comes after everything's already happened and it's the next day, right?
That is correct.
The only two messages, and here's what he said: "Good morning, beautiful. My list of things that I would do to you is very long and growing." 8:58 AM on March the 8th, okay? This is the next day. Mr. Barron has already, unfortunately, died at this point. Ms. Mericle's in custody, correct?
That is correct.
The only two messages visible on Ms. Mericle's phone between Mr. English and Ms. Mericle would have been this reacted note, right?
Yes,
And this message here. Right?
that is correct.
We know that Ms. Mericle told the first deputies that she told Mr. Barron that she was ending the relationship or moving on or something to that nature. Correct?
Hold on, I'm going to the transcripts. Which body camera are you?
I'm sorry? Yeah, that'd be Thomas. And you remember, it's on my flip chart as one of the things that they
Yeah, I'm
said.
just confirming, yes. I don't, it wasn't said to me, so.
I understand, but we know she
Yes.
said to them.
Yes, I'm just confirming because like I said, it was not said to me.
We know that Ms. Mericle said that Mr. Barron was very upset with her about ending the relationship, or words to that effect, to those first deputies. I know she didn't say it to you. Correct?
Yes, if that's,
We know that these two texts are on her phone, and we know, do we not, that this would be new information to Mr. Barron.
yes,
According to Ms. Mericle, this very much upset Mr. Barron that she might be moving on, having another relationship. At least that's what she said to the first deputies. Correct?
yes.
What is new with respect to Ms. Mericle's motive, as far as you know? What is new with respect to Ms. Mericle's motive? Not Mr. Barron's, but Ms. Mericle's motive on March the 7th or March the 8th? Motive.
Yes, I'm trying to debate some,
My question's very specific.
yes.
What's new?
So in this point, yes, we do have her drinking alcohol, and then we do have her with the Charlie English text. Those are the two deciding factors, yes.
That's what's new, is the Charlie English stuff.
Yes,
But that's not new to Ms. Mericle, that's only new to Mr. Barron, right?
allegedly.
Allegedly.
I don't-
It's not going to
can't.
enrage or unhinge Ms. Mericle to find the text that she knows she's got. Right?
Yes, but also keep in mind, we cannot confirm that he didn't know, but I would assume and make the assumption with you that he didn't. But
You did, just not 13.
Just not 13.
What was
I
14?
put down that you have
Wait, what was
14 and 15.
Yeah, 14.
Yeah.
Not 13.
14, 15, and not 13?
Not
Yes.
13.
15's been admitted, though.
Yes.
Yeah.
Okay.
14, 15.
Let me show you some of the material from defendant's 15. Yeah. Defendant's 15, these are the texts between, again, Mr. Barron and Ms. Mericle from March the 3rd all the way up until March the 7th, the night of the shooting, okay? Now, you remember some of the evidence, you've been in the courtroom throughout the whole trial because you've been permitted to stay in. Is that
Correct.
right? There was some evidence that we heard about the Bluetooth connecting to different cars. You remember that?
correct.
Okay. So I want to ask you specifically about this very final week, the March the 3rd all the way up to the March the 7th, that kind of 4-day window. Okay?
Correct.
We know that on March I think it was the 6th or 7th, maybe it was even the 7th. Ms. Mericle says, we went and got the provisional license for my, because of the DUI arrest. On
Yes,
March the
yes.
6th or 7th, I think it was, right? On March the 5th, March the 3rd, it's a message from Mr. Barron to Ms. Mericle asking, hope you arrived safely. This is 3:51 p.m. Do you know where it is Ms. Mericle is being well-wished about arrival? Do you know where it is she's going March the 3rd or arriving to?
Would that be the Sunday, Monday, so she could go back to St. Simon's?
So March 3rd, she heads back to St. Simon's. She's there Monday, Tuesday,
Yes,
right? Comes back on Thursday.
yes.
And Ms. Miracle's mode of transportation, March 3rd, 4th, is, as far as you know, and don't guess if you don't know, as far as you know, is the Kia.
Correct.
Meaning Mr. Barron's Kia is the way she's getting from Gainesville to St. Simon's, 5.5, 6 hours away.
Yes.
And this is presumably related to her travels on that March 3rd. She says she's getting on the causeway. The causeway, when you go to St. Simon's, you have to take the causeway to get over down there. Do you know anything about that down there?
In years.
Looking at March 3rd, 2025, 3:51 p.m. Mr. Barron to Miss Mericle, the car is running fine. He's reporting back, presumably about her vehicle, as far as we know.
Correct, that's what it says, yes.
Talking about a realtor code. All right, March 3rd, 2025, 3:56 p.m. Miss Mericle states to Mr. Barron, you had my house key on your key ring. I thought I had given you a key, thank goodness. Correct?
Correct.
And this very next message, which is sent March 3rd at 3:57 p.m. You see that? The
Yes.
time?
Mhm.
What we have here is an image that was sent. Right?
Yes.
Taking a look at that image and comparing it to Defendant's Exhibit 2, previously admitted.
Okay.
The Kia keys that were found inside of Mr. Barron's pockets at the hospital. Right, that's what Defendant's 2 is.
Yes.
Okay. Mr. Barron states on March the 3rd, it's working properly now. You know what it is he's referring to? It's working properly?
Making an assumption, I would say her Porsche.
She says that's weird, but I'm glad. Thank you. There's a hay in there. March the 4th, if Thursday is the 6th, the 4th would be Tuesday, is that right?
Correct.
7:31 a.m. Mr. Barron is reporting back to Ms. Mericle, I'm in the car and the blower won't come on. Correct?
That's what it reads.
She says, have a good day, sorry the car will not start. And then Mr. Barron responds March 4th, still that same morning, Tuesday morning, in an Uber going to rental car. Correct?
Yes.
And you're aware of some other evidence that he went and actually did rent a car? Is that right?
Yes, I believe so.
I did get a rental car. She was offering to actually pay for it. And he says, you're not to reimburse me. Don't feel bad. It's much easier. Okay? Let's move forward to March the 6th. March the 6th again is the Thursday before the Friday of March the 7th, the shooting March 7th, March 8th. We'll talk about timeline a little bit, but this would have been the Thursday right before, right?
Yes.
Ms. Mericle sends a message to Mr. Barron, I'm going to call the one in Beaufort and see if I can bring the car in Friday, if we can get it started. Right?
Yes.
And then March 6th, Mr. Barron says, they told me how to activate so we can take tomorrow. And that would have been 3:16 p.m. We're getting closer. Here we are, March the 6th, 2025 at 9:12 p.m. This again would be Thursday evening, right? March
Yes,
6th.
9/12, yes.
Thursday evening. I'm 30 minutes away from the house. Do you want to meet me somewhere to eat? By Ms. Mericle, correct?
Yes.
Mr. Barron responds, Taco Mac will serve till midnight. Can just meet you there. Correct?
Correct.
Text me the address, please, is the response from Ms. Mericle.
Yes.
And then there's a message sending probably some sort of an image about the address, we would presume. Is that fair?
Yes.
And then he gives her some further instructions, take the left off I-85 for shopping center on the right. That's at 9:17 p.m. on March 6th. Correct?
Correct.
Now, March 6th at 9:17, thank you. I am here. 9:32 p.m., correct?
33, yes.
Then there's no other messages between the two of them. Because she's now made it, right? She's in person when she gets there on March 6th.
Okay, yes.
And then the very next message after that break is on March the 7th, 2025 at 11:01 p.m. Correct?
This is the message I'm looking at, yes.
Yes. It's a Facebook share, right, with an image on it. Correct?
Yes. I believe so. I mean, it looks, yeah, it is Facebook share, yes.
And do you know what her daughter looks like, Mary Madden? Would you be able to identify her?
I think I saw her in one of the hearings one time,
Okay,
and no, I've been wondering if she was here all week, and I do not.
okay. You wouldn't be able to identify the person in that photo if you don't know what she looks like.
No, I do not. I do not.
11:01 PM, a message from Ms. Mericle to Mr. Barron on March 7th, 2025. Correct?
Yes.
Was not admitted, is that right? I didn't do 16. These are already, and this is 12,
Yeah.
and 10, and 11. You stack these up here. Jeff, can we switch back to the audio and video plan a little? These are tender? Okay.
Hall County 911, where's the address of your...
States Exhibit 1.
Did you say states one?
States 1, Judge, previously admitted. 516. You can go there. You can back it up just a tiny bit. Go ahead. 516.
Hall County Dispatch, how may I help you?
Hi, I need to ask someone to do a welfare check on my sister.
This 911 call has not been authenticated or admitted. This is not Ms. Mericle.
This
This
is
is hearsay.
this is the same exhibit the state tendered and filed a
We tendered.
pre-trial notice of a business record. It's been admitted in its entirety. This is
It's going to be a few minutes. Take a break. I'm guessing 10 minutes. Thank you. You can do what you need to do. Thank you. Y'all can be seated. You can take a break if you want. Lawyers and I are going to talk. All right. So, what was physically tendered by the state?
So, Judge, we tendered a flash drive with the whole audio clip of all the 911 calls that were provided to us by dispatch. It includes, at the end of it, a 911 call made by Dana, the defendant's sister. I cannot, edit. If I were to edit this clip, that would ruin the authentication of what was sent to us by dispatch. So I simply just didn't play the remainder of it for a lot of reasons. Number one, even if I did submit the business record notice to authenticate it, but that doesn't get rid of hearsay. That just goes to its authenticity. There's still the confrontation clause and hearsay that we have to think about when we're playing a 911 call made by somebody other than the defendant. The reason that hearsay didn't apply for her is because it was a statement by the defendant. So there wasn't the hearsay and confrontation clause issue with the two 911 calls made by the defendant. But as to the third 911 call that's on this audio clip, I did not tender that because it would have been hearsay and there would have been a confrontation clause issue. I believe what defense wants to play this for is for the truth of the matter asserted based off of what she says in the 911 call, and I believe that would be hearsay even if it is authenticated by a business record notice. There's still a hearsay objection. If they want to call Dana, that's perfectly fine. But just because a 911 call's been authenticated doesn't mean that we just throw out all the other rules of evidence and don't think about hearsay. So what the state tendered was...
So defense, as it relates to just that, and I'm not getting into what's been tendered at this point, but getting into what's been stated as far as the hearsay, what's your position?
Well, Judge, a business record certification, which is what was filed by the state pretrial. Now, I want to make sure that I'm being precise here. February 24th, 2026, 3:14 p.m. Notice of state's intent to introduce business record pursuant to 24-9-902. A business record that's got a certification, the reason that defeats a hearsay objection. So that's my first, I guess, point of contention is that it could be hearsay. It might ordinarily could be hearsay, but the state has actually literally removed it from the ambit of hearsay by filing a business record notice in 10 days advance of trial, as the code section permits, for only certain business records to be admissible without the necessity.
Doesn't that go to foundation of not having to have someone from Hall County 911 come in and say, yeah, this is the 911 call?
I think it's twofold when they file the notice. I think it's twofold. I don't think it's merely a foundational hurdle that it clears, because a business record is reliable. That means it defeats a hearsay objection because it is reliable, because it is kept in the ordinary course, et cetera, et cetera. That's what they chose to file under. I'm not even getting into whether or not that was correct for them to do it. Okay? That's a totally separate question. When they did that, we said, okay, I guess we don't need 911 dispatch here. This whole file is coming in, which is what we did. We relied on it. They tendered it.
We're getting into the business record as it relates to the 911 custodian coming in and talking about, yeah, this is our record.
Correct. That would also defeat the necessity of that. To have a business record certification also avoids a foundation problem. But it is also a hearsay tool to avoid a hearsay objection. Business records are admissible over a hearsay objection because they are business records. That's what the state filed and said, this is a business record. They gave us the notice. We relied on it. Then they tendered the file that has this call on it from the date that they outlined in their notice and said, hey, this is a March 8th call, which was to dispatch. It's been tendered. They didn't limit when they tendered the item. They didn't say, we mean this audio and that, and not the later audio. They tendered the entirety of it. Here it is. We're just playing the evidence that's already been admitted.
State?
Yes, Judge. Let's say, for example, the victim made a 911 call and I did a business record notice. That simply would just authenticate the call, but I would still have to come up with a hearsay exception to be able to play the victim's 911 call because it's still hearsay. Hearsay still applies. The same goes for this. The business record notice simply just authenticates the foundation for its authenticity as far as, like you said, not having someone from dispatch come in and testify to its authenticity. That doesn't mean that we just ignore hearsay. And so I completely agree. I filed a, can I see, Brett, do you have it on your phone, the business record notice? Can I just see it really quickly? Sorry, I was trying to find it and I just couldn't.
So I'm certainly subject to being wrong. Way we are right now, I believe that the business record would alleviate the necessity of bringing in a kind of a perfunctory witness to basically say, yeah, this is a 911 call. I don't think that notice, and I'm subject to being wrong, just lets everything in. Sort of the issue that I see here, and maybe I'm wrong, issue I see, and I've not done the case law research on this, but as a judge, 10 years ago, editing software was very expensive. Now, not so much. And so instead of editing beforehand, lawyers tend to do it in front of me, which is fine when you get it right. It's not fine when it's wrong. So, on some level, I understand the defense's argument of, well, they tendered the whole thing. And again, I'm not getting into what case law says about this. It'd be preferable just to edit out exactly what and inform the court, Judge, I'm tendering this flash drive that says, minutes, 00 through 2 minutes, 35 seconds. There's additional stuff, but that's edited out pursuant to whatever. So, on some level, when you're dealing with a document, if the state tenders a 5-page document and they don't like what's on page 3, well, tough luck. The whole page, it's all in there. With an audio, I think it's a little bit different because the whole thing's not the exact same. So a 911 call from one person, from a foundational standpoint of, yeah, these are all 911 calls, that's fine, but different calls from different people are not a uniform ruling. So, if someone wants to tell me I'm wrong, and I'll hear from you a little bit further, at this point, I'm not super inclined to go past the initial calls, and I do appreciate Mr. Van Rossum stopping that on objection. I do appreciate that. There's a button up here somewhere that I couldn't quite find, so I appreciate his professionalism in that regard. So my inclination is, I understand the defense argument, well, it's on a flash drive, we should be able to get into everything on that flash drive. I get that, and it's a compelling argument. That being said, these are not multiple 911 phone calls from the same person. They're intermixed and delivered that way from what I've been led to believe.
And just for the record, Judge, because I wanted to check on this, my business record certificate, I put So every time there's like a new caller, you get a new CAD report that has a new CAD number and dispatch number associated with it. And in my certification of records that I got from dispatch, I only put the dispatch number associated with the calls made by the defendant. I did not ask to be certified the call made by Dana, the third caller. So technically in the state's notice, I have not certified the dispatch and the CAD report for the third 911 call. I only asked to be certified the one made by the defendant. So I think that's important to note as well, that the third call has not been included in the state's notice of intent to introduce business records.
I'll give defense the last word with the court's inclination to not allow it.
Judge, the notice that was filed by counsel was ambiguous to me, which is why I replied to Ms. Bennett and said, is this the file that's called 911 calls? And she replied, yes, and I relied on that.
I'm sorry, the extent of that email was what again?
When I got the notice, and you'll correct me if I'm wrong.
No,
but-
that's correct.
When I got the notice that said, hey, we're going to put in these calls to 911, and it said they were on March 8th, which is all the calls that are on State's Exhibit 1 are from March 8th.
So to be clear, what was started to play as it relates to that 911 call, lack of a better term, I'm not concerned about authentication, to be clear for the ruling. I'm not doubting that it purports to be a 911 call. The issue I'm getting into is I don't think that the hearsay is as broad as you're purporting it to be. And if I'm wrong every day, and I'll take a lesson right here or in a few moments. But so to be clear, the ruling, it supports the state's contention that the certification, and whether you knew it or not, and I gotta be honest with you, I'm taking counsel at her word, that this is essentially, the CAD is a limiting thing. Whether you knew that or not, okay, I hate to say it, it is what it is. So, but my ruling isn't necessarily on that portion you wish to play was not properly authenticated. Because realistically, it's to potentially both parties' benefits, not to, and I'm not taking anyone's side, but maybe to the state's benefit to have Miss Lee Stallings Wood not sit in here for a day and a half or whatever, and maybe do 911 stuff instead. So in an effort to save some time and inconvenience of a rather technical witness, I'm okay with all this. So just to be clear on what the extent of the court's ruling is. Go ahead.
I just wanted to, I guess, lay a further foundation for my reliance interest on, because once we received the notice from counsel that said, here's a business record notice, there was no file attached to it. It didn't say, it didn't reference a file number, name, and so I went and checked, and the only file I'd received in discovery was a file that I think is entitled 911 call or 911_call or something. It's only one file. And it does contain all of these calls in that single file. In other words, it's not three files, if it pleases the court. And so what I did was say, do you mean this file? And she replied, Ms. Bennett replied, yes, this is the file that the notification respect to a business record notice applies to, in essence. And, in reliance on that, I presumed we were on the same.
So so foundation aside, what's your hearsay, if you have, let's say, a DUI caller, there's the exception, and then we get into,
Sure.
But there's all types of exceptions as to, third-party callers, which is essentially what I think this is purporting to be. The business record is that this recording, for lack of a better term, was done in the regular course of 911 business, which is fine. So where I think you're lacking, and if I'm wrong, let me know, that's fine, we can discuss that. I think where you're lacking is when you have a third party chiming in on this 911 call. That's where I think the state is correct.
And what I'm saying, Judge, is that in the universe that exists prior to someone filing an 803, 902, paragraph 11 or 12 notification, you're correct, right? But what I'm saying is we're not in that universe because the state filed a pretrial notice with an affidavit of the custodian, and that is...
So you're saying under 24.902 is where this comes in?
If you look at 803.6 and then 902.11 and 12 in reference to affidavits, so it's two different rules, right? You've got an 803 paragraph 6, and then you've got what's called a 902 certification.
Okay, 803 paragraph 6 and what?
It would be a
902, correct?
902 paragraph 11 and 12. These two things are working together, if it please the court. When you've done the affidavit and you've submitted something from a custodian and you file the notice, you're defeating not just foundation, you're also saying this is non-hearsay, which is why the rule gives the person to whom the affidavit is provided, it, first of all, it requires the party to file it within a certain time period for that person to then review the record and say, hey, does this meet all the qualifications to defeat both hearsay and foundation? That's what it's designed, so we don't do this in court like we're doing it right now, right? We'd hash it out. I would file something. If I objected, I would come to the court and say...
And I certainly get that as far as, let's say, again, please correct me if I'm wrong, I certainly get that as it relates to, someone's post record or someone's policy, what I would say a traditional quote unquote business record. So if we had a, 5-page business record of what the policy is on interviewing suspects on, at the law enforcement center, that one's easy for the court to understand. But here we have, it's not necessarily a 100% business record because 911 didn't produce the call, they're just recording it. So that's where I'm a little bit...
And I don't disagree.
Disjointed.
In fact, when I got it, I said, hey, this is not correct, okay? But I chose not to raise that objection because I'm obviously the adversary party. If I don't object to it and I want it admissible on those grounds and I don't have an objection, I didn't voice one. But the point is, they've been the proponent. They've said this is the file, right? And our rules are set up specifically for one party to say, this is what I want to do, here's the rule that I say applies, and I have the choice as the adversary party to go, okay, that's fine with me, right? And not to then go, wait a second, I don't even think this is a business record. I think this is frankly a public record, which is a totally different subsection, which we did not do, even though that was my position.
All right, help me through this. All right, so I'm looking at 902 24.902 self-authentication, paragraphs 11 and 12, which is what you directed me to. The original or a duplicate of a domestic record, meaning a Georgia record, of regularly conducted activity. So taking 911 calls would be regular activity. That would be admissible, and that seems to be a key phrase. That would be admissible under paragraph 6, 248803, which you indicated earlier, if accompanied by a written declaration, so we'll need to visit 803 in a moment, if accompanied by a written declaration of its custodian or other qualified personnel certifying that the record A, was made at or near the time of the occurrence of the matter set forth, or from information transmitted by a person with knowledge of such matters. B, was kept in the course of the regular conducted activity, and C, was made by regularly conducted activity as a regular practice. Pretty basic stuff there. A party intending to offer a record into evidence under this paragraph shall provide written notice of such intention to all adverse parties and shall make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with fair opportunity to challenge such record or declaration. And that was filed February 24th, 26. Okay, hold on a second. (24.8.803) subparagraph 6. Records of regularly conducted activity, unless the source of information or the method or circumstances of preparation indicate lack of trustworthiness, and subject to the provisions of Chapter 7 of this title, a memorandum, report, record, or data compilation in any form, all right, so that's important, memorandum, report, record, or data compilation in any form of acts, events, conditions, opinions, or diagnoses, if A, made at or near the time of the described acts, events, conditions, opinions, diagnoses, B, made by or from information transmitted by a person with personal knowledge and a business duty to report, kept in the course of a regularly conducted business activity, and D, it was, if I didn't say C, kept in the course of a regularly conducted business activity, and D, it was the regular practice of that business activity to make the memorandum, report, record, or data compilation as shown by the testimony of the custodian or other qualified witness, or by certification that complies with paragraph 1112, which we just talked about, 249902, or by any other statute permitting certification. The term business, as used in this paragraph, includes any business, institution, association, profession, occupation, and calling of every kind, whether or not conducted for profit. Public records and reports shall be admissible under paragraph 8 of this code section, shall not be admissible under this paragraph. Do we need to go to 8? I don't think we do.
No, sir.
Okay. I think B is pretty important. Made by or from information transmitted by a person with knowledge, so arguably the sister has knowledge, and a business duty to report. I think that's where it's problematic.
This is in reference to, they're talking about the creator of the record, not the speaker.
Okay,
So it's in reference to, in this case, it'd be 911.
fair point.
Right. And maybe can I email the court, or I don't know if you have the notice that the state filed?
I think
You do? You have the
Mr.
affidavit?
Preston was Johnny on the
Okay.
spot and
Great.
printed it out.
Fantastic.
All right. I'm going to take a few minutes on this. What else?
Nothing else, Judge?
Nothing else.
And to be clear, what you tendered in is on a flash drive where?
It is right
So
here.
you're using the exact same flash drive?
Exact same drive.
All right. I'm going to say 5 minutes, could be more, could be less. Thank you.
Hey, Brett,
Yes.
I don't know why I can't
All right, I'm going to say something to y'all in a moment. Anything you need to say to me?
No, sir.
Okay. Court's relying upon Glover v. State, Georgia Supreme Court, 285 Georgia 461, bless you. I understand this is after the evidence code change, but I think the logic still remains. And I'm going to quote from their opinion. Once a determination is made that a statement is non-testimonial in nature, normal rules regarding the admission of hearsay apply, citing Pitts v. State. Because the calls were placed within a short time after the shooting and the callers had no opportunity to deliberate about their statements or be influenced by others, the evidence was admissible under the res gestae exception to the hearsay rule. And I understand that that is old evidence, but I do believe the logic is influenced by others, and I'm making no comment one way or the other, but essentially, hey, you need to check on someone. I don't think that that's appropriate. Now, that's the ruling as it relates to the third-party 911 call. We have a secondary issue of essentially, lack of a better term, was the defense misled, tricked, whatever, or reliance upon, reasonable reliance, whatever you want to phrase it. I'm not finding that the defense was somehow tricked or, misled. Ultimately, this is a separate and distinct call from what they had tendered, even though it may still be on the same flash drive. And if that's wrong, then I'm wrong, but that's the ruling. Anything in response to button it up, make your record one way or the other?
No, Judge.
Anything from the defense?
We understand the court's ruling.
All right, bring the jury back. Thanks. And I assume the court reporter talked to you all about your mic. Welcome back.
Oh, we did.
If you're going to use it, great. If not, I don't have a problem with you all unplugging it, but if you're going to stand there and talk, make sure it's operable. Welcome back. Thank you for your patience. Thank you so much. Again, reminding you that the lawyers are doing their jobs. No one's done anything wrong, and I appreciate everyone's professionalism. Thank you. All right, y'all can be seated. Thank you so much.
You already had a trial. You have D16. So that should be 16. You finished on 15.
First witness, Judge. Showing you what's been marked as defendants 16 through 20. Take a look at those.
So you have this as
16 through 20.
where is the? Yes, missing some, but these are photographs I took.
And those are the photographs you took of Miss Mericle on March the 8th, 2025, At the end of the interview or during the interview?
My timestamp's about 6:30, 6:31,
6:31 a.m.
between the two.
Okay. And do those fairly and accurately represent how Ms. Mericle appeared to you on March the 8th, 2020?
You're missing some of the photos.
I understand, but do those photos,
On the bottom side, yes.
with respect to every one of those, do they fairly and accurately represent?
This is the exact photo I took, yes.
But do they fairly and accurately represent Ms. Mericle on that date, March 8th?
Yes, they're the ones I took, yes.
Okay. Moving to tender, defendants lost the numbers.
Sorry, so much. I want to notate these.
Any objection, state?
No objection to those photos, no.
Admitted, and just read what numbers you are again, please.
The numbers are 16, 17, 18, 19, and 20.
Admitted.
I'll show you on the Elmo, I want to show you defendant 16, okay? This would be the right-hand side here. Sorry, the left hand of the picture is Miss Miracle's right forearm. Right?
Yes.
In other words, she's like this. She's got her right arm on the right. She's got her left arm on the left.
That is correct.
And we can see what I'm going to call a reddish, dark red mark on that upper right arm, correct?
Yes.
And looking at defendants 18, looks awful like 16, doesn't it? Looking at defendants 17, we can see that same upper arm mark, slightly different angle, right?
Yes.
And defendants 19, that same mark, slightly different angle.
Correct.
Show you what I had. Approach witness. Approach witness. I'm going to show you what had been previously marked as JD1, JD2,
Yes.
JD3,
Yes.
and JD4.
Yes. You've shown me those before.
And I showed you these before in this courtroom when you testified.
Yes, yes.
And I asked you if those fairly and accurately represented how Ms. Mericle appeared on March the 8th, and you said yes.
Under the limited information with a few photographs I've had, I was able to look at photographs from other angles, and I do think I misspoke on a photograph or two.
Say that last part again. You think you...
I was ill-informed and I made a mistake and I misspoke. I don't think that there was some of the photographs that I took that don't depict some of the bruising further up the arm.
Okay. What you mean is you testified previously that these certain photographs did depict how Ms. Mericle appeared on March 8th, but subsequent to that, you don't believe that they do?
No, you showed me a few photographs, and it didn't sit well with me. I felt on the spot. And then I went back and looked at the totality, which is why I'm asking for the totality of the photographs I took, so we can talk about that.
Do you disagree that you previously testified that JD1, JD2, JD3, and JD4 did fairly and accurately represent how Ms. Mericle appeared on March the 8th?
I do agree that I did say that, and I was hesitant at that point, and I do regret that.
You regret it now?
Yes.
I'm going to tender defendants JD1, JD2, JD3, and JD4.
And Judge, may we approach?
Hold on.
For what purpose?
I'm not asking to approach.
I mean, I guess.
No, I'm asking you, what are you, you're tendering it for what purpose? And don't display them to the jury. Thank you.
That they fairly and accurately represent how Ms. Mericle appeared on March the 8th, 2025.
Okay.
Which the witness has testified that he previously affirmed.
Okay, y'all come up. Again, folks, the lawyers are doing their job. Thank you.
On February the 18th of 2026, you appeared in this courtroom as a witness.
Yes.
You were under oath.
Yes.
You took the same oath that you have taken today,
Yes.
and that is to tell the truth and the whole truth.
Yes.
And
Yes, that's what I tend to do, and that's why I'm saying what I'm saying.
And you were presented with JD1, JD2, JD3, and JD4, correct?
If those are the numbers, I don't recall. Yes,
That's a yes.
yes.
And you examined those photographs?
Briefly looked at them, yes.
Sure. I said, would you take a look at these? I'm going to show you some pictures, okay?
Yes,
And then I said, defendants 1, defendants 2, defendants 3, defendants 4, defendants 7, defendant 6, right?
yes.
And I asked you if these photographs accurately and fairly depicted how Ms. Mericle appeared on March the 8th, 2025, when you interviewed her at the Law Enforcement Center.
I was very hesitant, and I didn't have all the photographs that I took to be able to make a comparison. They weren't the same angles.
But that wasn't my question. What I said to you was, quote, just to be clear, defendants 1 through 7, that shows how Mr. Mericle appeared. They may have been taken by you or somebody else, but the point is, this is the way she appeared on March the 8th, 2025, when you interviewed her at the Law Enforcement Center.
And then there was objection, and yes, I shouldn't have answered that question, but I guess I felt on the spot, and I thought there are consistencies between the photos, but that is not how she looked when I interviewed her.
That's not my question. My question was, when I said to you, the point is, this is the way she appeared on March 8th, 2025, when you interviewed her at the Law Enforcement Center, your reply, sir, was yes.
Just to be clear, are we talking about the photos that are up now or the other photos
The photos including
Yes, okay.
JD1, JD2, JD3, and JD4.
Like I said,
Without displaying to the jury, please hand them to the witness.
yes,
Just hand them to the witness.
These are the photos,
yes,
right?
yes.
And I said, do these depict how she appeared? And you answered yes.
So I was looking at the bruising on 2 of the spots. This one threw me off because you gave me limited photographs to compare to, but the JD 2 and 1 really confused me, so I did further research. Yes, the bruising is far more advanced than it was on the 3 and 4 than it was at my time, but my problem is JD 1 and 2.
Was my question, do these relate? Do they accurately show how she looked on March 8th? And was your answer yes?
Unfortunately, at the time, yes.
And today, you're saying your answer to that exact same question under oath is no.
I was not prepared for that. This is the first time I've seen the photos. I made a hash statement, and I didn't have time to actually go through and evaluate them with the other evidence at hand.
It's nice to have all the information before you get asked questions, isn't it?
It would be yes.
It absolutely would be. If you don't have all the information, you can make a mistake.
Yes.
Asking you more questions about JD1, JD2, JD3, and JD4. You know that these were taken the next day after your interview with Ms. Mericle.
I believe you told me, yes, you alleged that they were taken from an attorney at the jail.
And you don't disagree with that?
I have no reason to disagree with that.
You're not telling this jury that these photos are from 2 weeks after March the 8th?
All I'm disagreeing with is the markings versus my photographs that I took, compared them. Only thing I'm disagreeing is the location between my photographs and JD1 and JD2.
Okay.
That is the only disagreement I have. Yes, when you say look the same, I was talking about 3 and 4's locations of bruising, but I wouldn't say they look the same. But they are same location is what I was testifying to.
Bruising in the location in the arm is the same on this photo here.
What can I say?
Yes, sir.
With
this photo
within
here.
respect to some of the photos you gave me, yes, but not some of them.
Are you contending that there was some sort of fakery of the injuries that are depicted in JD1, JD2, JD3, and JD4?
Absolutely not. Absolutely not.
What you're saying is, I can't say she looked exactly like that on March the 8th.
What I'm saying is, I didn't have all the information to my photographs because you presented me with a limited select few of photographs, so I could not see the tops to compare JD1 and JD2, and those are the two I'm disputing, that they don't look the same. Well, they don't, the bruising coloration is different, but I'm not arguing 3 and 4 locations. I'm not arguing that at all.
Are you arguing any of the locations on JD1, JD2, JD3?
I'm just saying, on my photographs, the ones that I took at the time of the interview, I did not see bruising where JD1 and JD2's locations are, and that's,
How are you purporting that those injuries got to JD1 and JD2 that you don't see?
well, bruising pattern does take time to take effect. And I'm not saying they weren't there, I'm just saying that they're not the same as the photographs I took, is what you said.
You would agree with me that the injuries to Miss Miracle's arms, or forearms specifically, left and right, those are significant looking bruises.
They're very bruised looking, yes. Now, significant's a relative term, but yes, they are bruised.
Fair enough. You would agree with me that something or someone certainly caused the injuries to Miss Miracle's left and right forearms.
Something would have bruised them, reaching through the door. There's several things that could have done it.
Is it your contention that the injuries to Miss Miracle's left and right forearms were caused by her striking the door with her forearms?
That, in the interview, she does make statements about that, and I don't know. I wish she would have been more willing to talk about other things that you're alleging, but
Well, we know from the text messages between Miss Mericle and Mr. Barron that Miss Mericle arrived on Thursday, March the 6th, and that this event was early morning hours of March the 8th, right?
yes.
Did you undertake any investigation to talk to anyone who may have seen Miss Mericle on March the 6th before she came to Hall County, and whether she appeared bruised or injured?
I believe everybody was so far away that, no, I did not go to St. Simon's.
Fair enough. Do you contend that any of the bruises or injuries to Miss Miracle's forearms were caused by something that occurred prior to March the 6th of 2025?
In the interview, I did ask if they were older.
Do you contend today whether those injuries were from something that occurred prior to March the 6th of 2025 when she came to Gainesville?
No.
In other words, it is not your theory that these came from some other place than 4238 Bay Ridge Drive in Hall County on either March the 6th, March the 7th, or the early morning hours of March the 8th.
I'm not saying that happened any other place. I'm just saying that the progression is different between the groups of photos, and that's what I was wanting to clarify in the location on 2 of the photos compared to the others.
Judge, I will move at this time to offer defendants JD1 through 4. For what purpose? For offering it as evidence of how Miss Mericle appeared on March the 8th of 2025, and the foundation for that would be the statements of the witness admitting that he previously testified under oath that they were in fact representative and fairly and accurately represented Ms. Mericle on March 8th, 2025. I know he's saying something different today, but of course it would be admissible as substantive evidence as impeachment, and we'd ask the court.
Well, there's two different steps then. So as not commenting on the evidence and not commenting on testimony, you've not laid the prototypical foundation for those photos. So that's prior objection is sustained. As far as impeachment issues, then I'll hear from you on that. Again, making no comment one way or the other.
The witness has testified, he previously testified under oath that they did. In other words, that they were fairly and accurately represented Ms. Mericle on March 8th, 2025. That is impeachment. It's a prior and consistent statement. It's admissible as substantive evidence. It's admissible as foundational evidence as well. In fact, it's not even a weighing situation, respectfully. It's just, has the statement been made in an admissible fashion, and it has. So it goes to weight. That's what cross-examination's for, or direct.
So Judge, there's no need for any sort of extrinsic evidence. The witness has not denied his prior statement. These photographs are not a prior inconsistent statement. They're photographs. They're not a statement. He's already questioned, cross-examined the witness about his previous statement. The witness has admitted to the prior statement and is explaining why that statement was made and why his answer might be different today. So there's no reason to put in photographs to prove a prior inconsistent statement that the witness has already admitted to. So again, there's been no foundation laid for these photographs, and I would object to them being admitted for any reason.
Defense has the last word.
Stand on our previous argument that we actually admitted.
All right. Again, not commenting on the evidence for purposes of the photographs. They will not be taken into evidence by the court, nor displayed to the jury through this witness.
Those are all my questions. Thank you.
Any redirect from the state?
Yes, Your Honor. Are these the ones that, these are, okay. Okay, thank you. Investigator Mefford, talking about the body cam, Deputy Thomas's body cam, did you witness the defendant doing anything with her limbs that could have potentially caused bruising?
Well, I mean, she was going to the ground, flailing about,
Did you ever witness her
on herself on the wall.
like leaning up against the wall with her arms, forearms, anything like that?
Yeah, she was going to the ground, to the wall, yes.
What about in your interview with her? Did you ever witness her hitting her limbs against anything in the interview room?
Yes.
Can you tell me about that?
Several times during the emotional theatrics outburst, and especially after I told her that he was deceased. She would go to the ground, stand up, go to the corner. At one point she did hit her arms on the wall. Yes.
And we know that in the door, there are a couple holes in the door. Do we know if she used one hand or one arm, both arms, to reach into the door to try and unlock it?
Trying to clarify, I know she stuck an arm through the door. I don't remember the quotes about how she went through, or one arm or both arms, but I do know she stuck an arm through the holes in the door.
So like, for example, states 225, Judge, are you able to flip it, or how does that work? Oh, there you go. States 225, we see this mark right here.
Yes.
Do you know how she potentially got that mark right there on her wrist?
I believe in the interview, she did say it was through the door.
Do you know whether or not is it possible that she could have also at some point reached this arm through the door to try and unlock it?
Yes, that is possible.
And so I'm going to show you states 224. We see we see a bruise right by the wrist and then higher up on the forearm.
Yes.
Do you know for a fact how those bruises got there?
No, I do not know for a fact how they got there.
Did she ever state whether or not she only reached this arm into the door, or whether or not she could have also reached this arm in through the door?
I know we talked about it at some point in the interview, but I can't remember the specifics. I can go back to the transcript and find it, but she did talk about reaching through the door.
Do you know, I know that sometimes pictures like mirror things. Do you know which arm is her right arm and which arm is her left arm?
This,
So like the one with the bracelet, which arm is that?
that's her left arm.
And then this would be her right arm?
Yes.
Okay. I want to ask you about, so Mr. Willis kind of talked about on scene in the body cam with Deputy Thomas that one of the officers tells the defendant that Mr. Barron is still alive. Do you remember that discussion with Mr. Willis on cross?
Yes.
And do you remember, Mr. Willis was talking about basically her statements before and after she found out that Mr. Barron, before when she thought Mr. Barron was dead versus after when she thought Mr. Barron could potentially still be alive.
Yes.
Do you remember talking with Mr. Willis about that?
Yes.
And there was mention that on cross that the defendant's statement started to change after she thought maybe Mr. Barron was still alive. Do you remember talking about that with Mr. Willis?
Yes.
Do you still have the transcript from the body cam up with you?
Yes.
Could you turn to page 26 and let me know when you're there?
I'm at 26.
So on page 26, at 1 hour and 5 minutes, is that when Ms. Mericle's told that Mr. Barron is still alive?
Yes, 105:23.
Okay, so this is the kind of the time marker for the switch of he's probably dead to maybe he's still alive on page 26.
Yes, from the verbiage, yes.
So what I want you to do, if you could flip to page 27. At 1 hour and 10 minutes, so this is now after she's been told Mr. Barron's still alive. At 1 hour and 10 minutes, can you read what she stated there?
So 110.
1:10:10.
Okay. He got mad. He wanted to sell, or he got mad. He wanted me to sell my practice for more and put the money in the house.
So I'm just going to go ahead and count. So that's one time she mentions him getting mad. If you could go down to 1:11:53 on that same page, can you read what the defendant says there?
He put his gun right to my mouth. He told me not to go. I better not fall asleep.
So, number 2, she's mentioning him putting the gun to her mouth after she believes Mr. Barron's still alive. If you could read at 1:13:30, what's said there?
Tonight, the last time he got like this, I called his son. He told me tonight if I called his son, he would kill me.
So, that's a threat. So we're going to count that as number 3 times that she has talked about Mr. Barron threatening her. If you could flip to page 28, at 1 hour and 17 minutes and 30 seconds, if you could read what the defendant says there.
When he hit me across the face, I think we may, or no, yeah,
Yep.
When he hit me across the face, I think we may have great families. We're good people. Peace, God.
So that was number 4. He hit me across the face. If you could flip to,
I'm gonna have to object at this point. That transcript was prepared by AI. I handed it to the witness to assist him. It's not accurate. I think they need to play the video instead of relying on a transcript. The reason I played the video and gave it to the witness so we could rely on the actual evidence, which is the video itself. I don't have an objection to them playing the video, but to just read the transcript, I object.
that's fine, Judge, I'll play the video.
ready?
It is loading. Now I am ready. Yes, Judge. So we're up to 4, Investigator Mefford, after she believes that Mr. Barron is still alive. I'm going to fast forward to 1 hour, 32 minutes, and 58 seconds.
He was gonna do something to him. I was.
All right, I'm gonna start playing at 1 hour, 32:48.
Oh, baby, be okay. Be okay. I should have told him that I was breaking it off. I was scared that he was going to do something to himself in there. He was going to hurt me and then hurt him.
So did you hear her say, I was scared he was gonna hurt me
And then hurt him?
and then hurt him?
Yes.
Okay, so on my count, that was 5. I'm gonna skip to 137:58. I'm gonna hit play at 137:55.
When he got mad at me, I should have just left, but I was scared because the last time he got mad at me, and I left, and I was so upset.
So right there, she's talking about being scared to leave.
Because the last time he got mad at me and I left him, I was so upset.
And then I'm gonna skip to 147:47. I'll start it at 147:30.
When he told me, God, I said, I should have just left. I said, open the door and put your gun outside.
So right there, did she say, when he told me not to go to sleep, I should have left, and then she says, I said, open the door and put your gun outside?
Yes.
My count is that 7. I'm gonna go to 149. I'll play at 149, 21.
I should just just went downstairs and just left. I was scared to leave. Last time we've gotten so many fights because of this. I should have just, when he put that gun to my lips.
So right there, did she just say when he put that gun to my lips?
Yes,
And again, did she also talk about being scared to leave?
yes.
And then at 1:51, I'm gonna play at 1:51:04.
I was scared to go to bed. I should have just left. I guess.
So right there, did she say I was scared to go to bed?
That is correct.
And again, are all of these statements made after she believes Mr. Barron is still alive?
Yes.
I'm gonna skip ahead to 2 hours and 16 minutes. I'm gonna play at 2 hours, 15 minutes, and 50 seconds.
Some men, and I stay there all night.
So no, I want to go to my office. I'm not wanting to go to the jail.
And then tonight, he threatened me, and I should have left, but I was scared.
So right there, does she say tonight he threatened me and I should have left, but I was scared?
Yes.
And then I'm just gonna keep playing. I'm gonna hit play again at 2:16:10.
And I want you to be able to tell me all about that.
I'm not scared. I just don't know what happened. He put that gun on my lips.
So right there, did she say he put that gun on my lips?
Yes.
I'm gonna hit play again at 2:16:40.
I've just had a really bad last year, this year.
Okay. So like I said, I want to talk about every bit of that. So
I don't want to talk about it. Everything was fine.
Whoop, it froze. Give it a second.
All I was trying to do, he shot the gun, and then I was trying.
Right there, did she say he shot the gun?
Yes.
So, in your interview with the defendant, again, when do you finally tell her that Mr. Barron is deceased?
Towards the very end. I don't recall the exact time or hour, but I know it was. So, in a 61-page transcript that I have here, it is on, 66-page transcript. On a 66-page transcript, it's on page 61.
And so basically, the very end of your interview is when she finds out that Mr. Barron is deceased?
Correct.
So the entirety of your interview up until that point, is it your understanding that she still believes that Mr. Barron could be alive?
Only thing I told her that I did not know, they were working on the hospital. I did not know at this time either that somebody said yes, but yes, he could have been, or he could not have been. I mean, she's also the one that said she couldn't feel a pulse, so.
But no one's told her, so since that officer told her that he left the scene still alive, nobody has told her differently at that point?
No.
So I want to now ask you just a few questions about your interview. Judge, if I could have I think it's up on the TV and I can't see. Oh, there we go. I'm gonna skip in your interview to 2 hours, 36. $2:36. We'll start here. I'll go back 10 seconds. I'm going to start it at 2:36:26. So when you leave, and now Sergeant Cuneo stays in the room, does the defendant talk about Charlie English?
Yes, I believe that was the first mention.
I'm going to hit play.
To be honest, I haven't been to the house, I haven't been to the hospital. I came in to meet with y'all.
I mean, God, I pray. But I know better.
Right.
It was a stupid phone.
And there's nothing on that phone that you didn't want him to see.
I mean, this guy was texting me, but nothing, I told him about the guy texting me.
Nobody like you're seeing.
So, if you can, what does the defendant say in response to there was this guy texting me? What does she say after that?
I told him about this guy texting me.
So does Ms. Mericle ever say that he saw the texts or he found out about him and got really mad, anything like that?
Not that I recall, no.
So she tells him, Sergeant Cuneo, I told him about Charlie English.
Yes.
Is there ever any mention by the defendant at all that Mr. Barron was angry because of seeing text messages from Mr. English?
I want to say there was I don't recall. I don't want to answer that question because I don't want to misspeak again and I want to be backed, but not that I recall, but I'm trying to think, was there? No, because she was telling me at first that there was nothing on her phone. To my knowledge right now, I think this is the first mention of it. Now, what was your question? I'm sorry.
Just besides this mention of Mr. English, is there really any other mention of Mr. English throughout your interview?
No, Mr. English himself, no.
And in this moment when she's talking to Sergeant Cuneo, does she mention anything about Mr. Barron being angry about Mr. English?
No.
In fact, she says that she's the one who told Mr. Barron about Mr. English.
Yes.
Okay. Lastly, I just want to go back to 205. Is it normal for individuals to be nervous when they're being interviewed by investigators?
Yes, when they first come in, that's when we like to establish that baseline, build a report so we get a baseline function.
Have you ever, when you're interviewing someone in a setting like this, seen someone kind of like shaking out of nerves?
Yes.
I'm going to go ahead and hit play at 2:05:07.
Like, say that's the door lock. I walked right up to the door. I think I put it up here. I can't remember if I stopped here, but then I saw it right above the door. I know that.
Okay.
I don't know if I.
So right there, can you describe what the defendant's doing?
She's making a gun with her fingers and pointing towards the little outlet cover in the interview room.
Is she demonstrating how she fired the gun at the door?
Yes.
Is she moving her hands up and down at pretty much 8.5 inches to demonstrate how she fired the gun at the door?
No.
I don't believe I have any other questions. Thank you.
I don't have any further follow-up questions for Ms. Goodman.
Thank you for your testimony. You can return to council table.
State rest, Judge.
State rest.
And at this time, I think we need to address the court.
Y'all come up for a moment, please. We're going to discuss scheduling. Thank you. Thank you both. All right, folks. I legally required to speak with the lawyers, which we'll do outside your presence. And short version is we're going to call it a day for your services. We will need you come back tomorrow. The state is rested. We'll do some lawyer stuff in the interim, and we'll start back again tomorrow morning. Should there be anything to start back, and then so 8:45 start at 9, and we'll go from there. All right. Again, please do not discuss the case with anyone. Do not do any research, in person, online, AI, none of that stuff. Thank you. Don't discuss the case with your family. Do not discuss the case with your family. Thank you. Y'all are excused for today. Y'all need a moment, or are you ready to roll?
We're ready, Judge.
Mr. Willis? All right. Y'all can be seated. We'll potentially be a while. Floor is yours, defense. Please, thank you.
Judge, we're moving for a directed verdict on all counts of the indictment.
Can't quite hear you.
I'm sorry. We're moving for a directed verdict on all counts of the indictment at this time. I think with respect to several of the counts, the tampering would be by inference. The malice murder would be obviously by inference as well. Behind a closed door, which is opaque, the testimony's been that no person could see inside. There's evidence about hearing. That'd be by inference. The aggravated assault counts, we believe, has not been met as well, beyond a reasonable doubt. We'll say the same with respect to the criminal damage first. I think I have all the counts. There's also the possession of firearm during commission of a felony, which,
You counts are malice, murder, felony, murder times 2, aggravated assault, criminal damage to property in the first degree, felony grade, possession of a firearm during commission of a felony, and then tampering with evidence, misdemeanor grade.
and the tampering charge, I think, is the strongest charge. Respectfully, we'll move for direct verdict on the remaining counts.
Not to quibble with you, nor, take anyone's side. On count 7, you said you believe that might be the strongest one. Walk me through that.
Well, it's still by inference, but there's the only person who could have flushed shells, spent shell casings, it would be Miss Mericle, it would seem. So I think that might be their strongest count. But as is our duty, we're moving for a directed verdict on all accounts.
Noted. Thank you. State.
Yeah, sure, just that Your Honor knows that the burden for directed verdict is just that there's some evidence as to each count, all the elements in each count, and state's position is that there's been more than enough evidence presented to reach that burden as to each count. I don't know if I need to go through each count to talk about all of the evidence that the state, but I mean, as to the malice murder, obviously, no one's arguing that Mr. Barron's not dead. No one's arguing that Ms. Mericle did not shoot him. So as to the malice, there's been plenty of evidence to show the malice, the walking up to the door, aiming, firing, and then staging the scene after the fact, Googling the Hall County Jail beforehand, all of the text messages. There's been plenty of evidence to go to malice as well as intent, malice, which is the intent to kill, to show that Ms. Mericle did, in fact, aim through the door in the direction of where she believed Mr. Barron to be, that she intended to shoot Mr. Barron and kill Mr. Barron. As to the aggravated assault and the criminal damage, which are the basis of the felony murder, there's been plenty of evidence shown that, again, as to the aggravated assault, that the defendant had a firearm that she offensively used by firing the firearm in the direction of James Barron that obviously ultimately resulted in his death, as well as the criminal damage to property that there's been plenty of evidence shown that she did interfere with the door knowingly and without authority interfere with the door, and that it was in a manner that endangered human life by shooting into a room that was occupied by Mr. Barron. There's been no evidence to say otherwise, other than she knowingly fired that firearm through that door, and that it had endangered Mr. Barron, as well as ultimately killing him, as well as the possession of the firearm during the commission of that aggravated assault. And then, as Mr. Willis said, the tampering with evidence, there's been plenty of evidence to show that Ms. Mericle did walk over to the toilet and flush the casings and the bullets. So, as to all counts in the indictment, Judge, I would ask that you deny the directed verdict.
Last word, defense. Anything?
Nothing further from us, Judge. Thank you.
All right, court's going to deny defendant's motion on all counts. The state's met its burden as far as this stage of the proceedings go. Certainly reasonable jurors may agree or disagree, and certainly that's why we have the beyond a reasonable doubt standard, and also their deliberations. But the state has put forth sufficient evidence to get past the defendant's request, and therefore defendant's motion is denied as to all counts. We will pick up tomorrow, same time. Dr. Mericle, you have the right to testify or not testify as you so choose. Silence cannot be used against you. If you wish to testify, great. If you don't wish to testify, great as well. Please understand you should certainly consult with your lawyers regarding this potential decision, but ultimately it's your decision and your decision alone, regardless of what your attorneys say or do not say, and that's none of my business. I'm not getting into that, but ultimately it's your decision to make. I don't need a response from you at this point, but I did want to make sure that I again advised you of that. Anything from the state?
No, Your Honor.
Anything from the defense?
No, sir. Thank you.
See y'all tomorrow.